Here, my lord, he has been interned for 447 days, my lord. Uh, in my case.
447 days.
My lord, 447 days I am inside.
So on what ground you are?
My lord, actually going through, your lordship will certainly say that since it is in the matter of on merit, so let the trial complete. Your lordship will also order for trial completion of trial in October 4th itself, but nothing is proceeded. Witnesses are yet to be examined. Your lordship kindly come to FIR, my lord. And Annexure 1, page
No, these
12.
things were considered earlier also.
Yes. My lord, one more very serious consideration is, my lord, whether there was compliance with section 42, 50 and 52.
In that case, my LCR may be called for, my lord. Yeah.
Uh,
Short.
Because, my lord, you will also kindly see now amended act has come.
Charge-sheeted matter.
Amended act has come, my lord, in 2022. You will also know, my lord, this is a draconian law. That's why procedural safeguards have been sufficiently provided. If there is any, my lord, iota violation, then, my lord, the accused is liable to get the bail or they be acquitted. When the ground
But
very ground is,
whether these pleas were taken up on last occasion or not.
that's what, my lord. Your lordship has given a very beautiful judgment on the plea taken by the lawyer. But I am on this different ground, my lord. That's why third petition. Otherwise, I would not come.
But is it open for the party to come? Suppose the lawyer fails to plead a ground which was available.
No, but in criminal law, I think that is not. In the civil law, of course, your lordship, what your lordship is saying in order to rule to bar the second plea. But in criminal law, my lord, because it involves human rights and, my lord, personal liberty, so that would not come. And it is legal ground, my lord. I am not taking any factual ground as such. The lordship can only see the FIR. On the facts also, my lord, there was another person on the pillion. He ran away. That's what the FIR also says. Whether that material was brought by him or by this man, there is always a pin of suspicion, my lord. Needle of suspicion. Second man was there. He was not caught by the police. He managed to escape from the pillion. That is one thing. And, my lord, section 42 now is amended in 2022. My lord, who authorized? Who authorized this seizure or arrest? The person who is authorized by the government of Assam and government of India is the authority to seize or arrest. You will also see the section
No,
42.
but it was during, what was the fact? It was during regular. With
It was during the
previous
Nakabandi, during
it is
Nakabandi.
during regular check.
Yes, that's what I am there. During Nakabandi on the road, they were caught. One fled away, and another caught. This man was caught. Now, my lord, what is the rule then? When anybody suspects, any constable who suspects, what would be the rule to be played by him before his materials are seized or arrested? He is to be caught and taken to the nearest magistrate or police station.
For this fact, my lord, we need the LCR, my lord, because we don't have the report with us.
Because it hits the very case what I have gone through today in the morning, my lord, because child was ended up by my junior yesterday. It hits the very root of the case.
It is from Kamrup, my lord, shortage
Yes.
may be given.
My lord, yes, otherwise, if the chance of conviction is bleak, my lord, there is no ground to detain him further. He is already more than 1 year, 3 months, 21 days. Otherwise, it is sufficiently long time. Your lordship said, my lord, 1.5 years is generally allowed by Supreme Court also.
But you have not completed that.
My lord?
Your detention is still less than 1.5 years.
Yes, just, my lord, by 1 month and 9 days.
Wait for that time.
No, my lord. Let the LCR come and we'll argue. I'll argue, my lord.
Mr. R.P. Sharma.
But your lordship, my lord, your lordship's judgment on the point argued so beautifully. I've got scripted.
R.P. Sharma, Learned Senior Counsel, assisted by Ms. P.
T. Som.
T. Som, Learned Counsel for the petitioner. Also heard Mr. R. Kaushik, Learned Additional Public Prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Abdul Mannan Ali, who has been detained behind the bars since 30/1/2023, within bracket, for last 447 days. It is
447 days.
It is also pertinent to mention herein that on an earlier occasion, when the petitioner approached this court, its bail was rejected by this court by order dated 4/10/2023, passed in bail application number 2932/2023. Stop. Learned additional public prosecutor submits that perusal of the scanned copy of the case record of NDPS case number 86/2023 would be necessary for consideration of this bail application. Hence, call for the scanned copy of the NDPS case number 86/2023, along with scanned copy of the case diary of Jalukbari PS case number 56/2023 from the court of where it is pending?
Well, Kamrup, rural Kamrup,
Which court?
Amingaon.
From the court
Not
of
coming to noise.
learned.
Not coming.
Jalukbari.
It is case additional at FTC2
Kamrup Metro,
Kamrup, sir.
Kamrup is Amingaon.
from the court of London, additional sessions judge
Kamrup Metro, sir.
within bracket
It's Metro.
FTC number 2,
Metro.
Kamrup Metro. Let this case be listed again on
5/4.
S. Nawaz will appear in this matter. I mean, pass for the timing.
Biswat Martin.
Lordship, this petition is filed praying for a direction to the UIDAI to furnish the information as regards the documents submitted against Lordship, 81 Aadhaar cards. Now, Lordship, under the Aadhaar Act, there is a restriction of sharing the information under section 28 and 29. However, Lordship, section 33 states that nothing contained in subsection 2, subsection 5 of section 28
You have
Subsection-
Aadhaar Act.
of the Aadhaar Act.
Act is there.
Aadhaar Act.
Okay.
I'm referring to section 33.
What it says?
I'm just reading a story. Nothing contained in subsection 2 or subsection 5 of section 28 or subsection 2 of section 29 shall apply in respect of any disclosure of information, including identity information or authentication record made pursuant to an order of a court not inferior to that of a judge of a high court. Provided that no order of by the court under this subsection shall be made without giving an opportunity of hearing to the authority. Lordship, I do not have any difficulty. Let them be heard. After that, it can be. Since it is in respect to the security of the country, Lordship, that is also taken care of in
No,
subsection.
Why you require this?
Lordship, in a case, if I may take your Lordship to my paragraph 1 of the petition. It is most respectfully submitted that in compliance of Government of India, Ministry of Home Affairs, so and so, dated 5/10/23, the NIA has registered RC 1 of 23. That is a case relating to human trafficking, dated 6/10/2023, under section so and so, arising out of so and so. Now here, Lordship, the authorities have found out, if I may take your Lordship to the next page, the subparagraph of paragraph 3, during investigation, it has been confirmed that most of the Indian ID documents seized from the accused person of Bangladeshi national appears to be genuine. However, it has been confirmed that the supporting documents furnished by the accused persons and their associates to obtain the Aadhaar cards are either fake or forged. So, Lordship, in order to verify the genuineness,
No, it is in relation to some pending case.
yes,
Human trafficking.
yes.
During investigation of that case, it
Yes.
was felt necessary.
Yes, Lordship. So my,
Whether only
at this
This-
moment, Lordship, we have found out 81.
authority is to be heard or the,
No, the
Fine.
UA, that authority has to be heard, Lordship.
not the persons whose,
Lordship, if they have furnished fake documents, that hearing will be later on. But first, since it has been submitted to the authority UIDAI, let it come from the authority first, Lordship. If Lordship feels at the later stage, because our contention is these are fake
no,
documents.
but there is a restriction in UADI Act that this information should not be,
Yes, there is a
disclosed.
restriction
that gives protection to the
That
applicants also.
that gives protection to the applicants, but section 33,
It says
yes, section 33 of the same act.
that only UADI has to be heard.
In fact, Lordship, I have annexed 2 judgments of the Madras High Court, wherein, Lordship, the prayer has been allowed at annexure D and annexure E, Lordship. If I may read page 49 of my petition, pertains to a judgment rendered by the Madras High Court, more particularly paragraph 8. If the Aadhaar card itself is not genuine, it is open to the respondent to inform the petitioner herein that Aadhaar card is fake document. First, let us see, Lordship, whether these Aadhaar cards are genuine or fake, Lordship. If the authority says these are fake, then perhaps those people need not be heard at all.
Mr. R.K. Dev Chaudhary, learned DYSGI, Deputy Solicitor SGI, learned counsel for appearing for the
Petitioner, Lordship.
Petitioner National Investigation Agency. This application under section 482 of the Code of Criminal Procedure, 1973 has been made with a prayer to direct the respondent authority to furnish the documents pertaining to Aadhaar numbers of 81 applicants who have obtained Aadhaar cards, and it is suspected that they have used fake supporting documents for obtaining this is the apprehension, obtaining the said Aadhaar cards. It is also submitted by learned counsel for the petitioner that as per section 33 of the Aadhaar within bracket targeted delivery of finance and other subsidies Benefits and Services within bracket close Act 2016. The said information may be disclosed by the High Court after giving opportunity of hearing to the authority that is respondent in this case. Hence, stop, hence issue notice to the respondent. They have any counsel stand,
They do not
Notice
have
will-
any counsel.
hence issue notice to the respondent. Then the petitioner shall take steps for issuance of notice by registered post with ID within 3 days from date of this order, returnable after 4 weeks,
Lordship.
list accordingly.
Also, Lordship.
My please, your lordship, the matter may pass over for it and
Timing,
yes.
May I please, your lordship? Kamil Patel, I get from Kamil Patel. Your lordship, the petitioner by way of the present petition has challenged the proceeding, your lordship, under complaint case number 224, your lordship, which was, your lordship, cognizance was taken against the present petitioner, your lordship, under section 500, your lordship, of the, let's say, defamation, your lordship. There are 3 accused, your lordship, 2 are before this honorable court, your lordship. The case in brief is this, your lordship. There is some land agreement for sale was executed between the mother of the petitioners, your lordship, and the complainant, your lordship. Now, the dispute cropped up between them, your lordship, regarding the payment, etc., your lordship. Ultimately, that case is, your lordship, pending before the civil court, your lordship, civil court, your lordship. And in the meanwhile, your lordship, the mother of the petitioners, your lordship, by holding a press meet, your lordship, brought certain allegations against the, your lordship, the complainant, your lordship. And that was published in a news daily, your lordship, vernacular news daily, your lordship. And ultimately, your lordship, in that particular case, your lordship, complaint case number 224 of 2023 was, your lordship, registered, your lordship, before the learned court below, your lordship. And ultimately, your lordship, in that case, your lordship, initial deposition of the complainant was recorded, your lordship, and thereafter, your lordship, if your lordship comes to page 72, that is the order taking cognizance and issuance of summons, your lordship.
yes.
Today, date was fixed for necessary order upon consideration of statement recorded under section 200. This is important, your lordship. CRPC. The content of the complaint as well as after hearing the learned counsel of the complainant, I find sufficient ground to proceed against accused person, namely so and so, Nirupama Borua, Jotin Chaudhary, Anupama Borua, Srimati Pallavi Borua, and Raj Borua, your lordship. Last 2 are the parent petitioners, your lordship. Now, basically, your lordship, we have challenged this order, your lordship, so far as the present petitioners are concerned, your lordship, on the ground that, your lordship, the mandatory requirement of inquiry under section 202 was not conducted, your lordship. Admittedly, your lordship, the petitioners, your lordship, are residents of, your lordship, beyond the territorial jurisdiction of the learned court below, your lordship. Number one,
Where do you stay?
no, Nagaon, your lordship,
And the case was registered?
registered at Guwahati.
Guwahati.
That is number 1. And number 2, your lordship, on the face of the complaint, your lordship, there is not a single allegation against the present petitioner, a specific allegation, your lordship, so far as defamation is concerned, your lordship.
The press conference was held by
Done
your
by the
mother.
mother, your
mother.
lordship. And documents he has annexed, your lordship, it is very categorical, your lordship. The photograph is of mothers, your lordship. The content is of mothers, your lordship. It is not his case that we were present and that press meet, your lordship. And on these 2 grounds, your lordship, we have put this to challenge, your lordship. Now, if your lordship, the
Now, mother is also an accused.
mother is accused, your lordship, but not before this honorable court, your lordship.
Okay.
Only the daughter and son-in-law. Even your lordship will kindly come to page 70, your lordship. That is the initial deposition of the, this is the statement recorded under section 200, your lordship. Even in this, your lordship, there is no specific allegation against the present petitioners. I am the complainant of the instant case. I have instituted the instant case against Srimati Anupama Borua, Pallavi Bora Borua, Rajnaran Borua, Jayanto Borua, and Jatin Chaudhary. On 24/2023, a false and fabricated and defamatory news item regarding me was published in the Assamia Proceeding. I had paid certain consideration amount of Srimati Anupama Borua for purchasing a plot of land for her sometime December 2022, but she did not give me possession of the said plot of land. When I insisted her to do the needful for giving possession of the said plot of land, she got, your lordship will kindly note, she got the said defamatory news item published against me in Assamia Proceeding. In the said news item, it has been written that I have obtained her signature at gunpoint in a bid to purchase her plot of land. I had never done any such thing as alleged against me in the news item. Due to publication of the said news item, my image in the society has been significantly defamed and I have suffered from immense mental agony due to the same. I filed an FIR before the police, Bosista police station sometime in April 2023 against Srimati Anupama Borua, Pallavi Borua, Rajnaran Borua. The said FIR was registered as Bosista PS case number so Bosista PS, but no action has been taken by the police as regards the FIR. As such, I have been compelled to institute the present complaint, your lordship. On the face of it, your lordship, not a single allegation in his initial deposition against the present two
In the
petitioners.
complaint and
In complaint, your lordship, I have annexed, your lordship.
whether any allegation against you?
No, your lordship, allegations are there, allegations that we have threatened him.
No, regarding defamation.
No, your lordship. Your lordship, if there is a general allegation, your lordship will find page 37, your lordship. Page 37. Just above para 13, your lordship. In the meantime,
Yes.
the accused number 3, 4, and 5 by cleverly managing the accused number 1 and 2 and their staff reporter of Nagaon got the said gross objectionable defamatory news item published in Proceeding in it issued at so and so. This is the only allegation, your lordship, so far as the petitioners are concerned, your lordship. Now that cannot be, your lordship, brought me, your lordship, within section 500, your lordship. Unless your lordship and your lordship will get the news item, he has annexed, your lordship, that is at page 44. Learned, your lordship, court below is required to apply its own mind, your lordship. Page 44. Murot pistol logai mohilak bhaboke. In this entire news item, your lordship, our names are not there, your lordship. It was the statement of the mother, your lordship, and they can proceed against the mother, your lordship. And there is a specific allegation by the mother against him, your lordship. Now, if your lordship takes up section 202, your lordship, for a moment, your lordship, that is the foundation of my case,
We are issuing notice.
lords. Until then, also, your lordship, this proceeding will be stayed
Mr.
for a bit.
S. Borthakur, learned counsel for the petitioners. This application under section 482 of the Code of Criminal Procedure. This is an application under 482.
482, your lordship.
The order of cognizance is dated.
Your
No,
lordship,
it is not under 397.
no, your lord, 482. Lordship,
Why have you mentioned
397 ought not to have been, that's it.
482 of the Code of Criminal Procedure, 1973, read with Article 227 of the Constitution of India, praying for quashing of the criminal proceeding of complaint case number 224/2023, whereby cognizance under section 500 of the Indian Penal Code was taken by the learned Judicial Magistrate First Class Kamrup Metro against the present petitioners along with some other co-accused. The petitioner's case in brief is the petitioners, namely Shri Raj Bora alias Raj Narayan Bora and Srimati Pallavi Borwa, who are the resident of Nagaon town. Who are the resident of Nagaon town and whose case is that the respondent number 2, Shri Amal Daka, had lodged an complaint case which was registered under section 500 of IPC as complaint case number 224/2023, wherein he has made certain allegation against the mother of the petitioner number 1, namely, namely Srimati
Lordship Anupama Borwa.
Anupama Borwa alias Nirupama Borwa, of making certain allegations, making certain defamatory allegation and getting it published in the vernacular newspaper, that is Assamia Pratidin, on which date it was
Your
published?
Lordship, that was dated, Your Lordship, 2020, 20th April, Your Lordship.
20/4/2023. Stop. It is submitted by learned counsel for the petitioners that the dispute between the mother of the petitioner number 1 and respondent number 2 arose due to a land dispute, due to execution of an agreement
Lords, regarding purchase of a plot of land.
regarding purchase of a plot of land. It is also submitted by learned. Where is the allegation that your mother called the press conference?
Lordship. Your Lordship will get it, Your Lordship. That is, Your Lordship, at page paragraph 12, Your Lordship. I have shown, Your Lordship. In the meantime, accused number 4 by cleverly managing the accused number 1. That is the only statement regarding Your
No,
Lordship.
but your mother called the press conference. That
Lord.
was, where is that statement?
Lordship.
Where is the complaint petition?
Complaint, Your Lordship, at page 20. It starts from 21, Your Lordship.
When this press conference was called for?
Your Lordship, that was on 19th, Your Lordship.
Where is this statement?
That, Your Lordship, he has not stated it. Page 20, para 26, Your Lordship, page 26, Your Lordship, may kindly come. That on 24/2023, aforesaid newspaper published a false and fabricated.
No, you have stated that your mother called a press conference.
Lordship, that,
Where is
Your
that?
Lordship, that actually, Your Lordship, that is reflected from the news item itself, Your Lordship.
That is not mentioned in the complaint petition.
No, Your Lordship, they have not mentioned it, Your Lordship. They have only said that on 20th, this was published, but the news item itself, Your Lordship, page 44, Your Lordship, may kindly see. Here's the news, 19th April. Your Lordship.
And in his initial deposition, he
has only said, Your Lordship, that on 24/2023, news item was published.
what was the line? who submitted that it is submitted by learned counsel for the petitioners that in her initial deposition before the learned judicial magistrate first class recorded under section 200 of the CRPC, the complainant, that is respondent number 2, had categorically stated that the defamatory news item was that the mother of the petitioner number 1 got the said defamatory news item published in Assamia Pratidin. And there is no allegation
Again,
as against the present petitioners in the initial deposition. It is also submitted by learned counsel for the petitioners that though the cognizance of offense has been taken by learned judicial magistrate first class Kamrup Metro, whose territorial jurisdiction extends only within the district of Kamrup Metro, whereas the present petitioners are residents of Nagaon town, and therefore, as per the mandatory provision of section 202, inquiry ought to have been done before issuing process against the present petitioners, which was not done in the instant case. And they have assailed the maintainability of the complaint case against the present petitioner on that ground only. Stop. Issue notice to the respondents, since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioners shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks.
yes,
In the meanwhile, considering the fact that in the initial deposition recorded under section 200 CR of the Code of Criminal Procedure, 1973, by the learned judicial magistrate first class Kamrup Metro, no imputation was made against the present petitioners. Also considering the fact that no inquiry as mandated under section 202 was conducted, as apparently where is the complaint petition?
Your Lordship, complaint is at page 26, 21, Your Lordship. And Your Lordship will get our names, Your Lordship, at page.
What address was shown? Nagaon?
Nagaon, Your Lordship.
Okay. As
Nagaon.
apparently the addresses of the present petitioners in the complaint petition has been shown as resident of Nagaon, which is beyond the jurisdiction of the judicial magistrate first class Kamrup Metro. Hence, till returnable date, the further proceeding of the complaint case number 224/2023 as regards the present petitioners is kept in abeyance,
Yes. Deeply,
list accordingly.
deeply.
It may be taken after some time. My senior selects another problem. May it please your budget. Here the petitioner has prayed for recall of the order dated 3/1 Lordship, 1/3/2024 Lordship, whereby warrant of arrest has been issued against a petition, these two petitioners Lordship.
Why warrant of arrest was issued? Where is the warrant? Where is that order impugned order?
Order, impugned order is at page 48 Lordship. The operative part related to is page 49, Lordship. Third para, Lordship, issue NBW against the accused person, namely Jugen Borua and Nipen Borua, Lordship. The reasons are not attached here with Lordship.
What is your name?
Jugen Borua and Nipen Borua, Lordship. Bura Gohai,
Nipen Bora Gohai
Bura Gohai,
and Jugen Borua.
Borua.
No summons were issued.
No summons were issued.
Okay.
And at this stage, I pray for LCR and
Let them appear
let them appear.
because summons were not issued. At the first instance,
Yes, someone has to be
non-valuable.
issued.
You appear before the court.
I may be protected.
No, whether any summons were issued.
No, no summons were issued. This is the first one.
How Mr.
As they shown.
S. J. Sharma, learned counsel for the petitioner. Also at Mr. R. R. Kaushik, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Shri Jugen Borua and Shri Nipen Bora Gohai, impugning the order dated 1/3/2024, whereby the Court of Learned Judicial Magistrate First Class Tibohagar in issued non-bailable warrant of arrest against the present petitioner in PRC case number 35/2024. Learned counsel for the petitioner has submitted that when the charge sheet was laid,
The sheet was
31/12,
31/12.
24. 24 or 23? Yeah, sorry. 24 hours.
against 9 accused persons,
Against 9 seconds.
charge stopped on the basis, where is the FIR?
Lordship,
FIR,
FI is at page. Lordship,
9.
page 9, Lordship.
learned counsel for the petitioner has submitted that on the basis of an FIR dated 31/8/2023, filed by one Pavitra Kolita before the officer in charge of Demo Police Station, Demo PS case number 47/2023 under section 395 of the Indian Penal Code was registered and investigation was initiated. Ultimately, after completion of the investigation, charge sheet was laid on
31/12/23. Page 16.
on 31/12/2023 against 9 number of accused persons, including the present petitioners under section 120B/1 395/506 of the Indian Penal Code, read with section 25 within bracket 1A, not within bracket, 25(1)(a) of the Arms Act. Learned counsel for the petitioner has submitted that on receipt of the charge sheet, the Court of Learned Judicial Magistrate First Class by order dated 1/3/2024, at the first instance, instead of issuing summons against the present petitioners, issued non-bailable warrant against both the petitioner merely because of the fact that both the petitioners were shown as absconder in the charge sheet. It is submitted by learned counsel for the petitioner that the law is settled in this regard, that even if the accused persons are shown as an absconder in the charge sheet, the trial court ought to have issued summons to the petitioners at the first instance, which the learned judicial magistrate first class has not done. Stop. Learned counsel for the petitioner has also submitted that the next date of the case is fixed on 22/4/2024, and both the petitioners are ready to appear before the trial court and ready to cooperate with the trial. And they may be given some interim protection so as to facilitate their appearance before the trial court. Stop. I have heard learned counsel for both the sides and have perused the materials on record. It appears from order dated 1/3/2023, passed in PRC case number 35/2024, that as submitted by learned counsel for the petitioner, the learned judicial magistrate first class has issued non-bailable warrant against both the above named petitioner at the first instance without issuing any summons to them, which was not the correct procedure to be followed. Considering the fact that the petitioners are willing to cooperate in the trial and are ready to appear before the trial court on the next date fixed, this criminal petition is disposed of with a direction to the above named petitioners to appear before the Court of Learned Judicial Magistrate First Class, Sibsagar, on 22/4/2024, and to facilitate their appearance before the said court, the operation of non-bailable warrant of arrest issued against them by the Learned Judicial Magistrate First Class, Sibsagar, shall be kept in abeyance till that date, that is 22/4/2024. On their appearance before the trial court, the petitioners may pray for any relief to which they are legally entitled to. With above observation, this criminal petition is hereby disposed of.
My pleasure. This petition is under section 482 for passing of the family court ex parte order under 125 CFC. Order
No,
is
but against family court order, there are other relief. You could have preferred a revision.
my lord, actually there is execution case. So and warrant also issued. Therefore, my lord, we are approaching.
No, if it is an ex parte order, there are other reliefs. You
Yes,
could
my
have,
lord, yes, we approached for other relief, but there is execution case pending, my lord. In case of execution case, my lord, the revision petition is not entertained. Can you see the page, my lord, page 40? The execution order, my lord.
no, what relief are you seeking in this case?
My lord,
Which order you are impugning?
Uh, actually, my lord, in the order, my lord, I want to remand back the direction to appear in the main case, my lord, by vacating ex parte order.
So there is a relief available in CPC for this. This is 125 case.
Be-
125 CRPC.
My lord, before the execution case. Now the execution case is going on and the warrant also issue, warrant is my lord in case 42. The main copy, my lord, and 41 is the.
No, but relief of vacating the ex parte order is available. Then why have you appeared
Yes.
before?
Yes, my lord, we approached that court,
Okay,
but
that was rejected.
in case of execution case pending, my lord, they denied to allow the revision petition. Therefore, we have High Court. And this similar page 42, the warrant. Before that, my lord, can they see page 24? She is my wife, my lord, there is no doubt about that. And the daughter is also above 21 years. My lord. Both are living with me, my lord. And in my house, my lord, I give them to stay there in my house and I stay separately, my lord. Before the Gaura. Thereafter, unknowingly, my lord, they are filing this 125 case, my lord, and release a order, my lord, by not giving this paper, my lord.
No, what relief you are seeking? Quashing of maintenance.
Then only, my lord, passing of the order, my lord. Order of the order of the 125 CRPC petition, my lord, page 32.
Which order dated?
Page 32, order dated, my lord, 28/2/2023.
You are aggrieved by the order dated 28/2/2023.
2023.
What relief was otherwise available to you? Had you not come under 482? 482 is not open for you. You should have preferred a revision.
Therefore, my lord.
And if there is a delay, you should have preferred condonation of delay petition. You cannot bypass that by filing an 482 petition. You satisfy the court that 482 is maintainable.
My lord. Therefore, in the obstacle part, my lord, I write it that read it section 397.
Then there is a limitation clause is there. If 397, you have already. What should I do? You satisfy the court. Otherwise, I will dismiss it.
My lord, list this matter day after tomorrow. I will check.
Decide on request of Mr. N. Burman, learned counsel for the petitioner, list this matter on 22/3/2024 in motion column.
Deep level.
May I please, lordships. This is my 482 petition, my lord, for quashing the, my lord, the FIR and the incidental proceeding in PRC case number, my lord,
574/2022. In this case, my lord, what happened? In the year of 2020, my lord, the father lodged an FIR against the petitioner, my lord, in respect of a motor vehicular accident, my lord.
Whose father?
My lord, a petitioner's father, my lord.
Your father
Yes, my lord.
lodged an
Lodged
FIR
an
against.
FIR against me, my lord, in
Okay.
respect of motor vehicular accident, my lord, in which, my lord, vehicle, petitioner's mother was the pillion rider, my lord.
Okay.
Now, my lord, as
On
amicable
whose
settle-
advice?
Yes, my lord. I have annexed, my lord, one document, my lord, and page 13, my lord.
Okay.
Page 13, my lord.
Now, what
Already-
is your ground for caution?
Yes, my lord, there is, my lord, an amicable settlement took place in between the parties, my lord.
Whether the offense is compoundable?
Even though they're not compatible, my lord, in 482, my lord, there are so many cases, my lord. The High Court is power to quash the, my lord, proceeding, my lord.
Third,
In
Mr.
the large number of cases, my lord, already passed the order.
Third, Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure from 1973 has been filed by the petitioner Ashraful Hussain, praying for quashing the FIR dated
2/11/2020.
the date of FIR is
2/11/2020.
2/11/2022, on the basis of which Borpeta PS case number 2315/2020 and PRC case number 574/2022 was registered. The petitioner has also prayed for quashing the consequential criminal proceeding registered on the basis of the said FIR. Issue notice. At what stage it is pending?
My lord,
At what stage it is pending?
my lord, is now appearance, my lord. Appearance, my lord. As a matter of the state, my lord,
No stage.
my lord, in this case already, my lord, I have annexed one document, my lord. The informant and the, my lord, victim has already filed an affidavit.
No,
my
you
lord.
appear before this court and then say,
Yes, my lord.
let the informant and victim appear before this court. Who advised you to, your father to file?
My lord, otherwise, my lord, there was grievous injury sustained by the mother, my lord. The police might have, my lord, then they have lost FIR and also got the compensation also, my lord, from the tribunal, my lord.
What was- As Mr. R. Kaushik, learned additional public prosecutor, has appeared on behalf of respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 and 3 are concerned, the petitioner shall take steps for issuance of notice on respondent number 2 and 3 for by registered post with AD with return within 3 days from date of this order, returnable on give a date after 1 month, 3 weeks, returnable on 26th April. When
Obliged,
is the next date fixed? When is the next date fixed?
Next date, my lord, I have to obtain the, my lord.
You have
I have
10,
to take
thereafter you will get stay.
just after 2 minutes, my lord.
No, on the next day we will consider. We'll list this method accordingly on
Short date, no, kindly fix, my lord.
26.
Obliged, my lord. Obliged.
Item number 1.
Not pleasant. So this is 439 application lordship. But earlier was disposed of with the direction lordship, we will find page number 20 lordship. And apparently Lordship and the matter was listed thereafter on 18 Lordship and direction was given to file additional affidavit to submit the victim statement Lordship. I have already.
Where is the additional affidavit?
And page number
Putul.
Lordship in additional affidavit, page number 29 Lordship. Additional affidavit, page number 29. There are 5 numbers of accused Lordship, all they are in outside Lordship, but I am only in the inside Lordship. And 4 numbers witness evidence already been examined.
What is your name?
Abdul Rahman Lordship.
Yes, Mr. Kaushik, go through the statement of the victim girl.
And otherwise, Lordship, all are equally involved in the offense as per the statement of the victim Lordship. Equally Lordship.
Statement to. We are not disputing any of this, my lord. So considering the fact that the bike in question was used in the commission of the alleged offense and the trial of the case is yet to be commenced, hence the Zimma petition is rejected at this stage, my lord. Well, it is only an interim Zimma, my lord, we are seeking, my lord. Eventually, under 62, the court can, after completion of trial, order confiscation if required, my lord.
If it is used
As commission, my lord, that only the court can decide after completion of the trial, my lord. Under 62, my lord. Sorry, my 63, my lord. Confiscation to declare.
the owner is not the
Not
accused.
the accused, accused, my lord, will fine.
Yes, Mr. Adar.
In my submission, Lordship, though in the police report, it is stated that it is not needed. But in page 41, Lordship, in the order, the main ground of rejecting the Zimma petition, Lordship, that the bike in question was used in commission of the alleged offense and the trial of the case is yet to be commenced. Hence, Zimma petition is rejected at this stage, madam. I have not found anything wrong in this order, Lordship.
No,
Since it is a revision petition, Lordship,
you cannot keep vehicle. If
Lordship.
confiscation proceeding is to be initiated, that has to be after completion of the trial.
Lordship.
During the pendency of the trial, the bike cannot remain in the police,
Lordship.
open police.
Lordship,
under
may I
open-
pray for a report from the police officer, Lordship?
Police has already
Already reported.
mentioned. Police has nothing to do.
Page 40.
Only we have to see whether the reasoning of the court is
Lordship.
okay or not. And to,
Because the other findings we are not disputing, my lord. Only, my lord, whether because Sundar Bhai Ambalal Desai also deals with NDPS cases, my lord, and finding remains
you
the
have
same.
that case, Sundarlal.
No, my lord, I don't have it readily available. My lord, fixes it after some time, I can furnish it, my lord.
Give that case.
My lord.
On the basis of that.
Or Mr. S. Nawaz, learned counsel for the petitioner. You find out that case.
Well, I'll put, file this after some time, my lord, then
Okay, then I'll dictate.
I'll get the copy. my lord.
Take it up after some time. Putul, all of this are the matter. I'll dictate that order after some.
Item number 6.
May it please your lordship. Lordship, I kindly peruse page 17. A elephant was seized and along with them, we were also detained. Lordship, page 17, may I read your lordship?
Page
17. With reference to the subject cited above, I have the honor to inform you that on 18th of March 2017 at about 1 AM to 1:30 AM, the Tayahum Jubo Chhatra Jubo Porikhod Bondo Pancha Ancholik Committee caught the two accused, Okhimjyoti Khonikor, aged so and so, along with one 16-year-old female elephant near Nagadan, suspecting device illegal, which was taken from Namsai to Arunachal to Tuli of Nagaland. But by using various pranks, the two ran away towards the jungle. They were namely so and so. So the main allegation is, therefore, page 18, you will see, therefore, I being the beat officer of Kothalguri beat, have ordered them to submit their legal documents within 2 days. But due to their inability and failure to submit their legal documents, I have seized the elephant and arrested the accused on 21st March 2017. The accused violated section 29, 39, 48A, 49, 49B, 50, 51, and 52 of the Wildlife Protection Act 1972. Honorable Supreme Court judgment, civil so and so. Then your lordship may kindly peruse page 21. Page 21 is the seizure list, where the elephant was seized, your lordship.
Okay.
And page 26, your lordship, is the offense report. And page 29, your lordship, the relevant portion, may I read? Your lordship, what it is.
Yes.
Page 29. On 18 March 2017 at about 1:30 AM, the Tayahum Jubo Porikhod Bhadoy Ancholik Committee spotted one female elephant coming from Namsai, Arunachal to Tuli of Nagaland. On way of their transportation at Nagajan under Kothalguri beat, the member of said committee suspecting them as illegal. At that moment, using various pranks, the two ran away towards jungle. The members of the committee ringed me and said about the elephant and handed over the elephant along with two numbers of accused, namely Okhimjyoti Khonikor and Midul Gogoi. I being the elephant with two accused to Kothalguri beat office. The elephant was seized by me on 21/3/2017 at 9 AM due to their inability and failure to submit their legal documents in due time. In this case, your lordship, Okhimjyoti Khonikor was granted bail by the Honorable Guwahati High Court.
He is one of the two persons.
Yes, your lordship. The present petitioner, page 24, your lordship.
Page 24.
Yes, your lordship. Case record put up today on the strength of petition number so and so, and the accused person, namely Okhimjyoti Khonikor and Midul Gogoi, are allowed to go on bail of rupees 10,000 each, with one local surety of like amount as per order of the Honorable Mr. Justice so and so, and the bail bonds of accused persons are furnished, and the same is checked and accepted after verification. So on 29/4/2017, I was granted bail, your lordship. Then your lordship may kindly peruse page 35 or 33. May I read, your lordship? The Divisional Forest Officer, Digboy Division, Digboy has submitted offense report by offense report number so and so, dated 21/3/2017 of under section 29, 39, 48A, 49, 49B, 50, 51, and 52 of the Wildlife Protection Act 1972 against the accused person Okhimjyoti Khonikor and Sri Midul Gogoi. Peruse CRN materials on record, finding prima facie materials on exist. I take cognizance of offense under section so and so of Wildlife Protection Act 1972 against the above named accused person. The case is transferred to London JMPC for disposal. 34, next page, your lordship. An order dated 31/3/2018, accused Midul Gogoi is present. Someone upon accused Okhimjyoti Khonikor returned after served. Hence, BWA bailable warrant of arrest of rupees 1,000 against the accused. Then, your lordship, page 36. This is an order 9/6/2022 passed by the Subdivisional Judicial Magistrate Margherita. 36, your lordship.
Yes.
Today is the date fixed for appearance. On perusal of CR, it appears that the case has been fixed at the stage of appearance since 11/7/2017. There are two accused persons in this case, namely Okhimjyoti Khonikor and Midul Gogoi. Accused Midul Gogoi is absent without any steps. Issue warrant of arrest against him. BWA issued against the accused. Okhimjyoti Khonikor is not returned with any report. In order to compel the attendance of the accused person and considering the fact that this is an old pending case, I deem it fit to issue warrant of arrest against the accused Okhimjyoti Khonikor. The OC of concerned PS is directed to execute the process and submit report on the next date fixed. Send a copy of this order to OC concerned, fixed 5/8/2022 for appearance. 37 next page, your lordship, the order 5/8/2022. Today is the date fixed for appearance. Warrant of arrest issued against accused Okhimjyoti Khonikor not returned with any report. Warrant of arrest against accused Midul Gogoi not returned with any report. On perusal of CR, it appears that the instant case been fixed at the stage of appearance since 11/7/2017. Issue fresh warrant of arrest against them. The OC of concerned PS is directed to execute the process and submit report on next date fixed. Send a copy of this order to OC of concerned PS 14/10/2022 for appearance. Page 38, your lordship. 14/10/2022, the order. Today is the date fixed for appearance. Warrant of arrest issued against accused Midul Gogoi and Okhimjyoti Khonikor returned stating that they could not be traced out. Issue PNA against them fixed 7/12/2022 for appearance. So PNA has been issued against me, your lordship. My respectful submission, your lordship, I have never received any summon, any bailable warrant or a non-bailable warrant of arrest which has been issued against me, your lordship. I am ready to face the trial, your lordship. Some protection may be granted to me at this stage, your lordship. I was not aware that the case is pending, that trial has started against me, your lordship. I've never received any summon. I've made categorical statement in my petition, your lordship.
No, but the observation of the.
Yes, yes, I understand, your lordship.
Court is that summons are duly served. So you have to show that something on record to show that summons were actually not.
To your lordship, I did not have that instruction, your lordship, with respect to the summon.
And lordship, there are Supreme Court judgments where it is said that anticipatory bail are rarely granted against judicial summons.
No, we are not
No,
granting. This is not a.
This is an
Applic-
anticipation, lordship of.
I'm not seeking bail, your lordship. I'm only praying that some protection may be granted because of the order, because I've never received any warrant of summons or any warrant from the honorable
Where is
court.
that statement?
Statement, your lordship, at page.
Warrant, will you will. not-
Bailable warrant, your lordship. Bailable warrant. Been corrected, your lordship.
Yes, bailable warrant was not returned
Yes, your
without
lordship.
report.
Bailable warrant was not returned. Page 7, your lordship, my petition. Paragraph 9, the second part, your lordship. Last paragraph. The line starting with the accused petitioner. Had your lordship got it, your lordship.
Heard
Page
Mr.
7.
T. Deori, learned counsel for the petitioner, also heard Mr.
I Bhattakur on behalf of Special PP Wildlife D
R.
Gogoi.
Thakur, appearing on behalf of Special PP
Wildlife
Wildlife, Mr.
D Gogoi.
D. Gogoi. This application under section 482 of the Code of Criminal Procedure, Common 1973, has been filed by the petitioner, Mr. Ashim Jyoti Khonikor, impugning the order dated 9/6/2022, issued by, passed by learned subdivisional judicial magistrate within bracket when Margarita. In which case it has been passed? In CR case
CR
number
case number.
06/2017, whereby warrant of arrest was issued against the present petitioner. It is, in this case, the petitioner has also impugned the order dated 14/10/2022, whereby learned subdivisional judicial magistrate Margarita had issued order for proclamation of the present petitioner as an absconder and attachment of his properties. The Learned counsel for the petitioner has submitted that on the basis of an offense report. Where is the offense report?
Page 26, your lordship.
On the basis of an offense report filed by Shri J.R. Das, my AFS Assistant Conservator of Forest. The CR case number 6/2017 was registered. It is also submitted by learned counsel for the petitioner that though the Court of Learned Subdivisional Judicial Magistrate First Class Subdivisional Judicial Magistrate Margarita by order dated 31/3/2018 had stated therein that summons issued to the petitioner had returned after service. However, he has never received any summons from the Court of Learned Subdivisional Judicial Magistrate Margarita. It is also submitted by learned counsel for the petitioner that the court thereafter issued bailable warrant of arrest. However, without receiving any report on the execution or otherwise of the said bailable warrant of arrest, the learned subdivisional judicial magistrate issued non-bailable warrant of arrest against the present petitioner, and thereafter, by order dated 14/10/2022, ordered issuance of proclamation of the petitioner as an absconder and attachment of his properties. It is submitted by learned counsel for the petitioner that petitioner is ready to cooperate in his trial. When the next date is fixed now, Mr. Deori,
I'm not sure. Next date, I'm not aware, your lordship, because
what is the status?
7/12.
Whether the case,
within 2 weeks, I will appear, your lordship. Your lordship.
whether the case has been filed or not, or it is,
It is pending, your lordship, against the other accused person.
okay. I have considered the submissions made by learned counsel for the there is the materials available on record. On perusal of the order dated 31/3/2018 passed in CR case number 6/2017, it appears that though it is mentioned that the summons have issued to the accused persons have returned after service. However, the order is silent as to on whom the said summons were served. Similarly, on perusal of the order dated 9/6/2022, it appears that without waiting for the report of execution of bailable warrant of arrest issued by the court, the trial court proceeded with issuing non-bailable warrant of arrest against the present petitioner. Stop. which does not appear to be proper procedure. Stop. Considering the submissions made by learned counsel for the petitioner that the petitioner is willing to appear before the trial court and cooperate in the trial, this criminal petition is disposed of with a direction to the above named petitioner to appear before the Court of Learned Subdivisional Judicial Magistrate Margherita within a period of 15 days from the date of this order, and to facilitate his appearance before the said court, the operation of order dated 14/10/2022, as well as operation of the non-bailable warrant of arrest issued against the present petitioner by the Learned Subdivisional Judicial Magistrate Margherita shall be kept in abeyance for next 15 days. Stop. On his appearance before the Court of Learned Subdivisional Judicial Magistrate Margherita, the petitioner shall be at liberty to pray for any relief to which he is legally entitled to. With above observation, this criminal petition is disposed of.
I'm deeply obliged.
Petitioner Nasir.
My lord, with all respect, my lord, here it is for quashment of a criminal proceeding, my lord. Here, Lordship, kindly turn to the FIR, my lord, that occurs at page 14, my lord.
Yes.
If it is read in totality, my lord. My lord, let me just read it, my lord. In reference to the subject cited above, I would like to inform you, while checking the CCTV footage, it appears that a bundle from the office premises have been taken out by one of our staff member, Priyanka Bora. On inquiry, Mr. Borua. On inquiry, Mrs. Borua has replied that she has not taken anything from the office premises. Here, it is mentionable that she generally used to come to office by car registered bearing number so-and-so, which is still parked at the main road near the branch premises. However, she had denied about the ownership of the car, and we suspect that some of the records, documents it might have been kept inside the vehicle. This is the FIR, my lord. Thereafter, it has been charge sheeted, my lord. And I have annexed the charge sheet that occurs at page 23, my lord.
You are Priyanka Borua.
Yes, my lord. 23, my lord. 23, my lord, last lines, my lord, of the charge sheet, my lord. My lord, page 23, last parting lines, my lord. Number 142 in Sanmari Police Station has been registered under section 409 IPC, and necessary inquiry has been made and statement of local people was recorded. One bag, this is very important, my lord. One bag, and this is the subject matter of the case, my lord. One bag containing voucher of daily transaction of said Grameen Vikas Bank has been seized from a Thar vehicle near the place of occurrence, and the said Mahindra Thar vehicle registered number so-and-so has been seized with its documents in connection with the aforesaid case. So, my lord, with all respect, my lord, from my vehicle, official documents have been recovered, and hence I have been charge sheeted under section 409 IPC, my lord. Now, regarding 409, my lord, let to come, the 409 is the penal section, my lord. Let me come to the
At what stage the trial is now pending?
may I please, your lordship?
At what stage the trial is pending now?
Just my lord, summons have been issued. Someone has not been issued, my lord. Charge sheet has been submitted, my lord. Now, my lord, with all respect, my
Charge
lord.
sheet submitted in the month of June.
Yes, my lord.
Till
But
now,
no summons we have received, my lord.
till now.
No, nothing we have. It has not started, my lord. But anyway, my lord, it doesn't sustain possibly, my lord, in accordance with law, it doesn't sustain, my lord. Lordship would kindly have a look at the 409 is the penal section, my lord. Let me come to the definition part of it, my lord. That is 403 of the Indian Penal Code, my lord. 405 of the Indian Penal Code, my lord. Mens rea is the main ingredient, my lord.
But you can make trial court also understand about 409 and 403.
That would be at the time of framing of charge,
Yes.
my lord. But that is redundant, my lord. It cannot sustain because apex court authorities are there, my lord. It cannot, under no circumstances, my lord. With all respect and full reverence, my lord. May I just read 405, my lord? May I read, my lord? What is is of utmost importance, my lord? 405 criminal breach of trust. This is the definition of 409. My lord. 409 is also included. Whoever being in any manner entrusted with any property or with any dominion over property dishonestly misappropriates. The authorities speak of dishonestly. The sine qua non is, my lord, with all respect and folded hands, my lord. If I retain something and, my lord, dishonestly, I have to do it with dishonest intention, my lord. That has to be there from the initiation, my lord. With all respect, my lord. This is very important. And thereafter, the penal section of 409, my lord. Now, my lord, from my vehicle, official files were recovered, my lord. Have I made my position clear, my lord? Now, my lord, the law, my lord, the authorities are, my lord, Article 141, my lord, with all respect, my lord. No, may I take a minute, my lord? Usko bila thik koi diga. This is one authority, my lord, with all respect, my lord, as reported in 21, my lord, N. Raghavendra versus State of Andhra Pradesh, my lord. There it occurs at para 47, my lord. Lisa, authority, Lisa.
And Raghavendra versus State of.
Yes, I am placing N. Raghavendra versus State of Andhra Pradesh, my lord, as reported in 2021 18 SCC, page 70, my lord. Duta ase no yat তুমি কি কাম কৰা হে May I read it and place it before you? I'm sorry, my lord. We have not done our
What is your submission?
My lord.
On what line you are going?
That, my lord,
409 is not applicable in this.
in this matter.
Because dishonest.
That paragraph exactly says so and exact tailor made, my lord. May I just read it,
But-
my lord?
This judgment is at what stage? Appellate stage.
My lord, whatever be the stage, my lord, the ratio would prevail, my lord.
No. Make me understand.
Yes, my lord.
The IO has submitted charge sheet under 409.
My lord.
First of all, whether dishonest ingredient of dishonesty is there or not, the evidence will be laid on that.
Yes, my lord. Can I place it in this manner?
Then, let me put my query.
Yes, I'm sorry.
The trial court may frame charges on under some other provision also, if materials are there. If at the stage of consideration of charges, suppose charge sheet has been laid under 409, but trial court finds that there are materials under other provisions, which
Lordship is very correct, my lord.
IO failed to mention.
Yeah, I'll answer your question as a student of law, my lord. With all respect, my lord. My lord, first of all, why 482 has been put there, my lord? Let me read. Lordship's query is, this is the procedure, my lord. So in Indian criminal justice delivery system, my lord, charge sheet is there, then summon it be issued, then in a summon procedure case, my lord, with all explaining offences, my lord, in a 409 case, my lord, with all respect, my lord, charges would be framed or charges, he would be discharged, my lord, at a time of framing of charge. These are there in the Code of Criminal Procedure, my lord, as it is existing today, my lord. Thereafter, intention of the legislature was clear, my lord. If there is any miscarriage of justice at any stage, that is why 482, my lord. And what 482 says, my lord, I can come anytime before your lordship with all respect and
No,
full
we have
reverence,
to
sir.
be, there are judgments that 482 has to be very sparing.
Yes, yes. It lordship would use it sparingly, provided
But if we-
materials are there.
But if we go by your submission,
My lord.
if we go by your submissions,
Ah.
in every case, people will rush to the court.
Yes.
For it.
Lordship is that way very correct, my lord. Lordship is-
Nobody will wait for the stage of charges.
No, my lord, both are to be read conjointly, my lord. The section of framing of charge in the Code of Criminal Procedure, as well as 482 of the Code of Criminal Procedure, my lord. Intention of the legislature was clear, my lord. That is why 482 was incorporated, my lord. And thereafter, my lord, with all authoritative laws of the Apex Code, that it is to be used sparingly, my lord. Lordship use it sparingly, my lord. It is a case, it falls in the category of, my lord, where even if you use sparingly, my lord, I fall in that category possibly because it cannot sustain, my lord. Because the reason, my lord,
Okay, we'll continue
my
to
lord.
hear you after I take a short break.
Oh, my lord, I'm sorry, I thought not. Obliged, my lord. That I can raise these questions at the time of framing of charge.
Charges.
Possibly that is your lordship's query, my lord. My lord, with all respect and folded hands, my lord. Yes, my lord. I can, I should. But my lord, when there is, any day is important, my lord. First of all, Article 21 will prevail, my lord. No person shall be deprived of his life or personal liberty except according to procedure established by law. Here, my lord, I would be facing trial in a case because I have come to, it is within the domain of my knowledge that it has been charge sheeted, my lord. With all respect, my lord, someone has not been issued, may have been issued, my lord. I have not received it, my lord, with all respect and full attention, my lord. Now, question is this, my lord, whether I should wait because that mental agony is there, my lord. When prima facie and ex facie no case. First of all, my lord, prima facie and ex
Now,
facie no.
how ex facie, there is no case because
Only because of the reason, my lord. Only material against me, they cannot improve it, my
you
lord.
were found
In possession of documents.
in CCTV camera
Yes.
taking the documents.
Yes,
And you were found, those documents were found in your car.
my lord.
So prima facie materials are there against you.
I have understood, my lord. Lordship is meaning that if 409, I may fall in the ambit of 379 at the time of framing of charge.
Either of two. May,
At the
I
time
am
of.
not saying like that.
No, I have understood, my lord, the tenor. With all respect and folded hands, my lord. Now, my lord, with all respect, my lord, that is, my lord, it is a double-edged sword, my lord. What would happen, my lord? I, as an accused, will try to protect my interests, my lord. That would be premature, my lord. Whether at the time of framing of charge, whether some other section of law would be attributed or not. That is, my lord, that would happen on a future day. But as on today, prima facie or ex facie, the materials are only the documents seized from me. And I admit, yes, the documents has been seized from me. But mere seizure of documents, my lord, with all respect, my lord, cannot bring me within the ambit of 409 of the IPC, my lord. So, as on today, my lord, with all respect, my lord, instead of facing trial and agitating my grievances at the time of framing of charge, would be, my lord, preposterous, my lord. Because that is why, with all respect, my lord, intention of the legislature was quite clear, my lord. 482 was incorporated, my lord. Have I made my position clear, my lord? Because I can come at any stage of the trial.
No, documents were found in your
Yes.
possession.
Yes.
Your only contention is that it was not with any dishonest intention.
Absolutely, my lord.
Is there
They-
any other contention
No.
that there was no dishonesty?
No dishonesty, my lord. Because what benefit I get, my lord? Official documents, I do my homework at home, bring it to office next day. Some my colleagues somewhere, my lord, may have done it, my lord.
Is it your contention?
Yes, here. Carrying documents home, my lord, an official file is taken home, my lord, that cannot be an offense, my lord. If theft is to be committed, my lord, it is to be taken away all throughout. Have I made my position clear, my lord? The documents, I cannot use it for my own benefit, my lord. With all respect, man. And that is the law laid down by the Apex Code. Let it be at any stage.
No, but what are the materials?
The only material against me, my lord, against me is this, that, my lord, official documents were allegedly seized from my vehicle, my lord. Meaning thereby I was to carry it home. Next day I would have again come to office, my lord. This I have been doing it since generations, my lord. Because, my lord, some animosity there, my lord, that of course is a, my lord, state of mind. Somebody informed someone and now 409. But it cannot fall within the ambit of 409. And if the state intends, my lord, at a later stage, they can challenge it, my lord. When 409 is not there, I am facing trial, I would be facing trial, may face trial under section 409 of the IPC. 409 of the IPC is the penal section, my lord. And the definition part is, my lord, 405, my lord. And 405, that dishonest word, my lord, is not applicable to me, my lord.
No, how at this stage we will find out whether dishonesty was there or not.
At this stage, my lord.
It
At
shall,
this
it
stage,
shall
definitely,
only
my
be
lord.
presumed that from the statement of the witnesses recorded under 161, dishonesty must reflect.
Then lordship may have to call. Can I come more prepared, my lord, with all respect, my lord, because this query I never expected, my lord. Lordship, if calls for the scan copies, then lordship would get the 161. But, my lord, if I get authorities to the effect that express on the documents on the basis of the charge sheet itself, if 503 ingredients are not there, then I get the benefit under 482, my lord. Let it come any day, my lord, with all respect, my lord.
In the meanwhile, let us call the scan copy of the case diary.
Lordship may. Yes, yes.
Mr.
Lordship,
Das.
lordship may, my lord.
I only want to state here, Lordship, my learned senior has stated that the documents have been taken as a daily work, Lordship. But in the FIR, she replied that she has not taken anything from the office premise. Moreover, Lordship, I want to state that in 409, there is the line, Lordship, and not only entrusted, Lordship, or with any dominion over property in his capacity of a public servant or in any way of his
No,
business.
their only submission is that there was no dishonesty.
Lordship, if
Other,
without any authority,
No,
Lordship,
he is
documents has been taken, Lordship.
He is correct, my lord. He is correct. But so far as the statute is concerned, authorities of the apex court talk in a different manner. So can it be like this, my lord? As lordship has, my lord, if your lordship calls for the scan copies, I stand on a better footing, my lord. Or otherwise, my lord, lordship, my prayer may be allowed. Let it be passed over, my lord. I can come with further prepared with further authorities, my lord, to the effect that, my lord, the documents or whatever materials are there in the charge sheet is enough.
okay, we are issuing notice.
Then lordship would call for the scan copies, my lord, in my prayer, my lord. That'd be better. Lordship would call for the, because everything will be palpable, my lord, 161, whatever evidence is available, my lord.
Heard Mr. B.K. Mahajan, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, read with Article 227 of the Constitution of India, has been filed by the petitioner, Ms. Priyanka Barua, praying for quashing the FIR dated,
Dated, my lord, I'm sorry, my lord.
FIR dated
Well, lordship will continue with the order. I'll give the date, my lord.
21-3.
21-3, my lord.
21-3,
22, my lord.
22, on the basis of which Chanmari PS case number 142/22 was registered, and thereafter charge sheet was laid against the present petitioner under section 409 of the Indian Penal Code. The submissions, learned counsel for the petitioner submits that ex facie, the ingredient of offense under section 409 of the Indian Penal Code are absent in this case. Stop. To consider the submissions made by learned counsel for the petitioner, perusal of the scanned copy of the case diary of Chanmari PS case number
My lord.
142/2022 would be necessary. Hence, call for the scanned copy of the Chanmari PS case number Scan copy of the case diary of Chanmari PS case number 142/22. And issue notice to the respondents since the learned additional public prosecutor has appeared for respondent number 1. No formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable on at a date after 3 weeks.
স্যার অলপ সোনকাল দিলে ভাল তাই এসিএস পাইছে স্যার
19,
হাইলি অবলাইক
19.
হাইলি অবলাইক item number 21 to 23.
Wait, please. I'm appearing in
22, 23 to AK.
21 and 22, I'm appearing. Your Lordship.
23 to AK.
23 is also similar, my 11th AP. Here, your lordship, basically, I will take your lordship to the FIR at page 15. The first item, 21,
Just a minute.
page 15. My case is very simple here, your lordship. Basically,
21.
20, first item 21, your lordship will take. Page 15 is the FIR, your lordship. In this case, basically, your lordship, as per the FIR, the police, your lordship will actually take it up from page 16, second paragraph, the main incident is there. Your lordship. First part is basically the police information and all. I'll not read those. Page 16, second paragraph. Accordingly, all our police team involved in the search operation proceeds immediately to Sunapur Toll Plaza, as it was a suitable place for us to detect and intercept the vehicles used by the peddlers. And at about 1 AM of 11/7/2023, the peddlers were traced leveling in two vehicles, a Hyundai Creta and a Honda City. The vehicles of the peddlers were tried to be stopped at Sonapur toll gate. However, the peddler in the Creta vehicle bearing registration number so and so hit the toll gate's barricade and sped off towards the direction of Guwahati. One round was fired aiming at the tire of the vehicle to prevent it from escaping, but the bullet hit the body of the escaping vehicle. One of the police team gave a chase to waylay this fleeing vehicle, but it could not be traced out as it managed to escape or hide somewhere under the cover of darkness. On the other hand, the Honda City vehicle bearing registration number so and so was able to be intercepted at the Sunapur toll gate by our joint police team, and the lone peddler, namely so and so, son of so and so, who was inside the vehicle, was caught hold of and detained accordingly. During search of the Honda City vehicle at the spot and in the presence of independent witnesses, suspected heroin of 145 numbers of packets kept inside as many soap cases wrapped in a plastic gunny bag have been recovered from the rear passenger seat of the vehicle. As such, the suspected heroin was weighed by me with the help of the digital weighing machine belonging to STF in presence of independent witnesses, and a net weight of so obtained was 1.873 kg, excluding the soap cases. The above mentioned recovered items along with the Honda City vehicle were seized by me as per seizure memo prepared in presence of independent witnesses. Plastic seal was used for the purpose of sealing the exhibits. I'll not read the rest, but your lordship, this person is not before your lordship. The other person, the person before your lordship is another person who was arrested in another case, your lordship. And this under this registered case, he was shown arrest by this one. I am in this case, I am the shown arrest part. Yeah, that your lordship will get.
What is your name?
Lordship will find at page.
Khalilur.
Shown arrest prayer at page 22.
You are Khalilur Rahman.
I am Khalilur. I am not here in this case. My name is not there in the FIR. The other person I am not appearing. Annexure, page 22 is the shown arrest. In the shown arrest prayer, your lordship, the police has come
to the finding that I am the other person who was there in that Creta, Hyundai Creta.
Who fled
Car.
away?
Yes, that car who has actually ran away, fled away, and I am the person concerned. And I was shown arrested after 70 days, 70, after 2 months, 10 days of the date of the FIR. And on the basis, only on the basis of the statement of the co-accused person. This is basically the case, Your Lordship, and nothing was recovered from me. Only the car was found, and myself, I was arrested shown arrested because I was already arrested in another case. In that another case, that case is, Your Lordship, STF PS case number, not Guwahati PS case number 111/22. So my only prayer, Your Lordship, is basically that this is, in this case, basically the only ground on which I am arrested. I'll come to the other case later on. This case, the co-accused version, whatever, then I am arrested after 70 days from the time. And that was shown arrested by.
What was the allegation against you?
In the other case.
No, in this case.
In this case, my allegation, it will come under 29, say that I am also a drug peddler who is associated in this case, because I was at that point of time, I may be there in the Hyundai Creta car. I must have been there in the Honda Creta car, which has broken the that barrier, toll gate barrier. That is basically on which basis I am arrested.
But in your car, nothing was found.
No.
Your car was not stopped. You broke the barricade and
It was
fled away.
broke, the barricade was broken, and
And
as per the allegations, I went off. There was a firing was done, but I just went off to go towards Guwahati, that's all. And then ultimately, after 70 days, I was shown arrested wherein I was arrested in another case, and then on the basis of the statement, most probably on the statement of the co-accused, because there's nothing else against me in this case. Other case I will come, other case, there are some allegations there, but that case of not Guwahati case, but this case, this is the only allegations here.
Now, what is your submission in this case?
So my submission is limited to the fact that, Your Lordship, nothing is recovered from me. The second part is that only I am arrested on the basis of the statement of the co-accused, Your Lordship. That part, on Tufan Singh part, I will just rely. Other than that, Your Lordship, except that the allegations,
Yes,
I was
there is
there in the
there.
Creta,
Yes,
there
there
or
is
not
there.
was not.
Lordship,
Case there is there.
this is scan copy, Lordship.
It is a charge sheeted case.
Charge-sheet.
So
This
apart from,
actually, this matter, Your Lordship has earlier rejected on the ground that the charge sheet was filed. The rejection order is there. Your Lordship will find the rejection order at page 37. Page 37. Lordship has rejected only on the ground that charges has been filed. And the Lordship is directed to approach the trial for regular. There is nothing, not on merits.
no, in charge sheet, apart from the statement of co-accused,
There is, Lordship, page
whether
56.
other
56
materials are there.
56 page in the charge sheet, Lordship. Page 46, first para, Lordship.
How will you bring him, associate him with this case where 1 kg is,
Next
Because
paragraph. your
transfer of
Next paragraph.
transaction is there, Lordship. Transaction between the accused person and this person only.
no, there is no, it is only mentioned that
In 46 paragraph, second paragraph, the statement, this, it has been stated.
no, in 161 statements
Lordship.
recorded during the investigation. Apart from the co-accused, Mofizul, whether is there any other material? If there is material, then his Tufan Singh goes. If there is no material, then he may get
Tufan
bail.
Singh.
Moreover, section 37 is also there, Lordship.
No,
Because
some
of this
material
case,
has to be there.
Lordship.
Some material has to be there. You go through the case diary.
Lordship.
Your only submission is that on the basis of statement of co-accused, you were arrested.
Yes.
And there is no other material.
No,
Apart from-
they have also stated that nothing was found from him. That is stated in the search sheet itself. In the second paragraph at 46, it is
This
stated.
is
though
a case
the-
under 21C/29 conspiracy. So you are roped in under section 29.
20. So there has to be something. in
Some
between
material to show that
to
you
show
are
that in this case, I am also in.
involved. That he is involved in the conspiracy, transportation, sale, purchase. Some evidence which you will adduce during the trial.
It will come out at the trial stage, Lordship. Through the evidences, Lordship, of the witnesses.
No, his submission is that there is no material.
No, prima facie it is there, Lordship. Moreover, he is also involved in other cases, Lordship.
Other cases part goes.
Lordship.
Other cases, your lordship will be, I'll argue on that
we
later.
will-
This part only this.
In this case, what
No.
materials are there?
As per the search sheet, it is there only, Lordship.
Where? Show-
Only that, Lordship, the money transaction is there, as per the IO, Lordship.
No, IO has said that he, as such, deposit of huge amounts of money running to crores rupees during the period under scrutiny from 2012 to.
Lordship, moreover, the transfer of large
It is
amount
really
of,
suspicious.
Lordship, moreover, the transfer of large amount of money between both the accused persons also established their connection of being involved in the illegal activities because nothing common was found between them except their complicity in illegal drugs trade, Lordship. Moreover, the transaction history of the bank accounts of both the accused persons also revealed that.
Yes,
most
how
of the
will
people-
you overcome this observation, Mr. Manna?
Lordship.
This, moreover, the transfer of the large amount. There was transaction between you and the
Lordship, that-
co-accused. And the IO has come to the conclusion that this transaction could not have been for any other purpose except for drugs, because nothing was common between.
Lordship,
So that is enough for,
Lordship, that is
framing
the
charges.
point, Lordship.
then your bail is rejected,
I'll leave it to your lordship.
then it is rejected.
Yes.
I'll pass orders in chamber.
The second one also, the same, the other case, your lordship, here. I don't think I have to argue, same points I have taken. Here, your lordship, there is some more evidence against him. This is the North Guwahati PS case.
No, let me dictate this.
North Guwahati PS case, second one. Similar matter, similar case.
In another, Lordship. Here the cases, there are two.
Second case. Next,
Second case, the second page, serial number 22,
Lordship,
item
in,
number 20.
in the search sheet, it is a name there, Lordship.
Here he is named.
Search sheet, in the search sheet, Lordship. Two cases are involvement of this petitioner. In two cases is there, in page 45.
Anyway, your lordship, if the lordship first case goes, the second one, there are involvement is there. So I
it is there. Okay.
admittedly, your lordship, I cannot hide those things.
Lordship.
Since,
In-
but
in-
trial, later on in the trial, it's a
In first
different
case,
aspect.
First means item number 21. Heard Mr. Y.S. Mallan, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner, namely Khalilur Rahman, alias Khalilur Rahman, who was arrested on 26/9/2000. He has been shown arrest in this case
In this case, is shown arrest.
and
Shown arrest.
shown arrest on
26/9.
who
23.
was
Shown arrest.
who has been shown arrested on
26/9.
26/9/2023 in STF police station case number 6/2023 corresponding to NDPS case number 1/2024 under section 21C slash.
Sorry, shown arrest date is 21/9, not 26. Okay, okay.
21C/21/29 of the NDPS Act. It appears from record that on an earlier occasion also, when this petitioner approached this court, his prayer for bail was rejected by this court by order dated 5/1/2023 in bail application number 4128/2023 on the ground that the quantity of contraband involved in this case was commercial quantity, and embargo of section 37 of the NDPS Act comes into play in this case. Learned counsel for the petitioner has submitted that the petitioner has been shown arrested in this case after 70 days of the filing of charge sheet. That too on the basis of the statement made by the co-accused, namely Mofizul Haq. It is submitted by learned counsel for the petitioner that apart from the statement of co-accused, no other material is available on record. Stop. And hence he has prayed for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has, referring to the charge sheet, copy of which is available before this court, has submitted that there are materials in this case to show that there was transfer of large amount of money between the accused persons, that is the present petitioner and the co-accused Mofizul Haq, and it also, and because nothing common was found between them except their complicity in illegal drug trades, the materials are there against the present petitioner under section 29 of the NDPS Act. Stop. I have considered the submissions made by learned counsel for both the sides and perused the materials on record. On perusal of the charge sheet, it appears that apart from the statement of co-accused, there are other materials which implicates the present petitioner in this case. And as this case involves contraband involving commercial quantity, involves contraband of commercial quantity, the embargo of section 37 of the NDPS Act comes into play. And the petitioner has not been able to convince this court that there are materials to overcome that embargo. Hence, the prayer for bail of the present petitioner is hereby rejected
At this stage,
at this stage only.
at this stage,
Rejected.
maybe because later on, after the trial also something might come up. So I'm just saying for that.
In next case,
Second case, your lordship, FIR is at page 13. Here, your lordship, the same Hyundai Creta is in there, belonging to the petitioner.
same incident,
No, not same incident.
but
This is,
but in that car, something was found.
yes, in the Thar it has been.
In,
It was found in the Thar. And this was similarly, your lordship, basically the similar. Here also the petitioner was named in the FIR, but the contraband was found in the Thar, not in the Hyundai. There is a relation, the correlation has been done by the, I think in the chart sheet. So this should also have the same fate.
okay. Heard Mr. Y.S. Manan, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mohammed Khalilur Rahman, who has been arrested on 11/9/2023 in connection with NDPS case number 3/ in connection with North Guwahati PS case number 111/2023 corresponding to NDPS case number 3/2024 under section 21C/29 of the NDPS Act, 1985. Stop. The NDPS case number 3/2024 is presently pending in the Court of Learned Sessions Judge Kamrup. The gist of accusation in this case is that on which date the affair was filed? Date of affair? On 11/9/2023, one Saddam Ansari, SI of police of Rani Police Outpost had lodged an FIR before the officer in charge of North Guwahati Police Station, inter alia, alleging that on that day at about 4 p.m. an information was received through reliable sources by the additional SP within bracket headquarter Kamrup that the present petitioner along with his associate Inamul Ali and Abdul Ali would be carrying some contraband in black color Hyundai Creta vehicle bearing registration number AS01FE1589 belonging to the present petitioner. Accordingly, a Naka checking was set up at Amingaon near Saraighat Bridge and stop Saraighat Bridge. At around 7 p.m. on that day, a Thar vehicle bearing registration number AS01FM7800 was found coming from Guwahati side. And when the same vehicle was tried to be stopped, the occupants of the said vehicle made attempt to escape from the said vehicle. However, they were apprehended. They were namely Mr. Haupu Singh Song, Mr. Gogo Haukip, and Mr. Samin Gong Dongel. Your name is inside of it. At page 14. During interrogation, those apprehended person informed that the present petitioner and his associates were waiting for them in front of Hotel Sanchaika in Amingao. Stop. During search operation, during search of the seized Thar car, on being pointed by the apprehended persons, 170 numbers of soap boxes containing suspected heroin were recovered from hidden chambers of the said Thar cars, said Thar vehicle. And the total weight of the recovered contraband was found to be 2 kgs 100 gram. Stop. What is your submission? Mr. Mandan,
Lordship,
or you surrendered? No submission.
yeah, Lordship, nothing, I should not
Okay,
make.
I have considered the submissions made by learned counsel for the parties as well as peruse the materials on record. As apparently it appears that there are materials implicating the present petitioner in this case, and as the quantity of contraband seized in this case is of commercial quantity, the embargo of section 37 of the NDPS Act would be applicable in this case. Hence, and there is no material on record to overcome the said embargo in this case in favor of the present petitioner. Hence, the prayer for bail by the present petitioner is hereby rejected.
Third case, though I am not there, my learned friend is there. It is the same one, the other two persons along with Khalilur Rahman.
Third lordship, come into consideration, that lordship, they have got no direct involvement, lordship. Neither that person have told their name, lordship, only this Khalilur is there. And accordingly, lordship, that was
Inamul and Abdul Ali.
Abdullah, lordship, that was.
Those 3 persons told your name in earlier case.
No, Abdullah, that has not been mentioned by that person, only Khalilur name is mentioned by them.
No, no.
And
I have
as per,
dictated the name of Abdul Ali and Inamul.
Inamul is also present in the
3
car.
persons
But
who were in
no-
the Thar vehicle.
that I understand, but no clear transaction or that nothing has been specifically
How
mentioned
they
in
are
the-
involved?
only against the Khalilur Rahman lordship. And that is why lordship, he was arrested subsequently in the next case, lordship, the Khalilur Rahman, not these 2 persons lordship.
This Inamul and Abdul
He just accompanied lordship without knowing the fact lordship that transaction would be done there lordship. Being of the same locality lordship.
Lordship,
They
chain of
accompany him.
circumstances is there. How they, from where they came,
They
how
are
they,
nearby, lordship.
where they placed,
They
at
were
Amingao,
waiting
they
for him,
were
lordship.
placed.
No
lordship.
specific lordship, no transaction, bank transaction like the
lordship.
earlier case.
Chain is
That
there.
is
lordship.
why the Khalilur was picked in the second case, lordship. These 2 persons were not picked in the estate case, lord.
Chain is there. lordship.
This case is same case. This
Case
is
is same, but the person were not picked up in the second case. Lord. That is
Now,
why
what is
lordship,
your
no bank
submission?
nothing has been found, lord.
What is your submission?
Submission, lordship, that it will rely upon the Tufan Singh, lordship, because no specific lordship as per the
Only on the
allegation
basis
made
of-
by lord. Only because of the coil and the
of the circumstances, Lordship, we are along with Khalilur Rahman. Khalilur is the main Lordship. As per record revealed, Lordship, in the earlier case also and this present case also, Lordship. That is why, Lordship, then subsequently the next case he was taken into custody, shown arrest was made, Lordship. Not these two persons. This is the first case, Lordship. Main case, subsequently the second case where Khalilur was.
No, if you,
No, this is the main case, Lordship.
if you say first case, second case, I will not understand.
No, because initially, Lordship, this.
There are two cases,
Lordship, two cases,
but
Lordship.
these three case pertains to two cases.
Lordship.
In first case where Khalilur's bail was
Khalilur
rejected,
were arrested first in this case, this present case.
and in the second case which.
Second case, subsequently, Lordship, when transaction and all has been there, thereafter he was taken into in next case. And these two persons were Abdul and Lordship Inamul were not made shown arrest in the subsequent death case. Lordship. They were just accompanied without the knowledge, Lordship.
Lordship, in page 30, Lordship,
Just
there is clearly written, Lordship.
3 of 20.
After
Your name is also there in the FIR. And as associates is there. Chain of circumstances is also
No,
there.
FIR is made after arrest, Lordship. The police has lost this FIR, Lordship. By that time,
Thus, you go through the case diary
Lordship.
in case number, not Guwahati PS case number 111/23.
Lordship.
What are the materials against?
The case earlier, Lordship,
No,
it
no,
is there,
in
Lordship.
this case,
Lordship.
111/.
111 or earlier was 111 only, Lordship.
No, this is the 111, which we are.
this is the
dealing-
triple one. This is initially where
This
Khalilur
case
was
is 111, in
I-
which
I
he is
understand.
seeking bail.
No, I understood, Lordship. In the earlier
Listen
one,
to my query.
Lordship.
In this case, you go through the case diary,
Lordship.
111/23. Find out what are the materials against Inamul and Abdul Ali,
Lordship.
apart from the statement of co-accused. Then we will consider it.
because, Lordship, as per his charge sheet, Lordship.
Your
the only-
submission is, apart from the statement of co-accused, there is no other.
No, Lordship, we are just victim, Lordship, of the circumstances. Lordship. We are along with the Khalilur, police is looking after Khalilur Rahman, Lordship, as per this man. And is what my learned friend has submitted, Lordship. After arrest, the FIR has been lost by the police. So by this time, they have known our name, Lordship, that we are accompanied with Khalilur Rahman, Lordship. It was
Let
the
us-
FIR is not that a prior FIR was lost,
Lordship,
Lordship.
other three persons are also there
Huh?
in the third Lordship. They also name Lordship,
Oh.
not this only Khalilur Lordship. The three persons in the third car Lordship who have transporting the materials Lordship. There is also name Lordship.
No, Lordship, FIR
That is
was.
their Lordship.
You are
we
found, you are found along with,
That is the
Khalil.
circumstance,
only
victim
found-
of circumstances. I agree, Lordship. We are with them, with Khalilur Rahman, Lordship, without the knowledge that he is there for receiving some consignment, Lordship. That was not in our knowledge. We are in the car waiting there without the knowledge. And as per that, other than that, Lordship, no bank transaction, nothing previous records were found. The Khalilur Rahman, there is a previous record is there. He was earlier arrested. Police was looking after him, Khalilur Rahman. Khalilur Rahman is the main Lordship for the police. And subsequently, when arrest was made, thereafter the FIR has been lost, Lordship. That is why names were there.
Lordship, the facts are that three persons are there in the
No,
third
no.
Lordship. They have bring
He
that.
have not understand the point, Lordship.
let him submit.
Lordship.
You
He
make,
have
the-
not he thought that the FIR was previously lost, thereafter action was taken, Lordship.
no,
If
Mr.
first they were arrested,
you make your submission so that I understand.
no, my
I'll-
submission is that, Lordship, it is reliable purely on Tufan Singh, because except with him, Lordship, nothing was found, Lordship.
Your submission is
yeah.
accept the statement of
Lordship,
co-accused, but
Lordship.
one fact remains that you were found in the spot.
That I admit, Lordship, I was
That
with
is an
Khalilur Rahman.
incriminating material against you.
The Khalilur Rahman is the police is looking after Khalilur Rahman. We were with him without the knowledge, Lordship, whatever, but without that, Lordship, whether any transaction or any dealing previous record, that matter also to be considered, Lordship, for consideration of the bail, Lordship. Like the previous case, Lordship, that Steve here, that huge.
No, there
crore-
may not be,
No, that Lordship, that were crores of rupees were transaction in the bank account with these two person, with whether something, some material.
there may not be any transaction between you and, because you were, both of you
I
are
understand.
the associate of Khalilur Rahman, that is the
Understand,
allegation.
Lordship, being standing or being together, Lordship, whether any drugs has been recovered for us, from us, the co-accused has said the consignment was supposed to deliver us, but it was, police did not arrest us at the time of delivery, Lordship. Because the vehicle where the consignment was kept, it was locked in a hidden chamber. It was open thereafter, Lordship. It was not that at the time of delivery we were together, police caught us red-handed. It is not the case, Lordship. It is only basis of the co-state accused that they were going to deliver the consignment to Khalilur Rahman, Lordship. And unfortunately, we were there, Lordship.
You
How
go-
the case
go
can be
through-
established,
Go through
Lordship?
the case diary. We'll hear this matter.
And-
Let him go through.
Lordship, as he is
My
submitted, Lordship.
I'll only want to state here, Khalilul and this person on the same footing, Lordship.
How
They are
dare
not
to-
different, Lordship.
No, no.
They are on the same footing, Lordship.
Same putting with any previous record must be there, Lordship, because it is not case that at the time of delivery of the consignment, we were caught red-handed. If it would been done,
Go
it is
go
different
through
thing,
the
Lordship.
case diary,
Lordship.
flag the
Lordship.
materials which are against him, I will
Lordship.
consider.
Also, it will be kept as part of Lordship.
No,
No, Lordship,
today
I
itself,
will flag it.
Not
Lordship.
today itself.
Today itself.
Lordship.
I will flag it, Lordship.
it will be
Lord.
disposed of today itself.
Lord,
Second hour.
only that part may be considered, Lordship. Otherwise, Lordship, we are being together, it would have been at the time of delivery of the consignment, then I have no submission, Lordship, because we are
Let
there.
him go through, let him go.
That specific material should be there.
After
Lordship.
lunch, we will consider.
Lordship, Lordship, much obliged, Lordship, much obliged, much obliged.
Lordship submitted, Lordship. Yes.
Charge sheet submitted against,
Only message is given, Lordship. From the office.
you appear before the trial court.
Otherwise, this is 438 bail application, Lordship. And I was not directly involved, but the co-accused statement was there, Lordship.
Now charge sheet has been laid. You will receive summons from the trial court.
Lordship.
Heard, Mr. Ajay Das. Now, what is your name?
M. Rahman.
Heard, Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Though the case diary was called for in this case, however, learned public prosecutor has submitted that in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
9/2024, dated 26/2/2024.
in view of the submissions made by learned counsel for the, in view of the fact that the charge sheet has been laid. This case, this anticipatory bail is disposed of with an observation that the petitioner may approach the trial court and seek necessary relief before the trial court, if so advised. With above observation, this anticipatory bail application is hereby disposed of.
Obliged, Lordship.
Item number 3.
Well, in this case, since the Zimma petition was rejected after submission of charge sheet minor, so the dichotomy of 451, 457 will not be in play. It will be covered by 451, so my lord Sundarbhai Ambalwal Desai will be applicable. My lord will kindly come to page paragraph 15, my lord of Sundarbhai Ambalwal Desai. This part deals with disposal of vehicles, my lord. And my lord, relevant
Charge
part,
sheet-
para 15, my lord.
charge sheet has been laid,
Charge sheet is
therefore
laid, ma'am. That's-
451 would,
451 will be applicable.
para,
Para 15, my lord, the part dealing with Zimma of vehicle starts, my lord. And relevant will be, my lord, para 17. If I may read, my lord.
yes.
In our view, whatever be the situation, it is of no use to keep such seized vehicles at the police stations for a long period. It is for the magistrate to pass appropriate orders immediately by taking appropriate bond and guarantee as well as security for return of the said vehicles if required at any point of time. This can be done pending hearing of applications for return of such vehicles. Para 18, my lord, will also considers the fact that even an accused can claim vehicle, my lord. No, my lord, will kindly come to para 20.
You are not accused.
I am not even an accused, my lord. Para 20, my lord. Para 20 recognizes that, my lord, 451 is also applicable in case of narcotic drugs, my lord. So an implication is also derivable from here, my lord, that even in NDPS Act cases, my lord, 451 is squarely applicable. So soon after
Read 20.
20, my lord. Similarly, for narcotic drugs also, for its identification, procedure under section 451 CRPC should be followed for recording evidence and disposal. Its identity could not be on the basis of evidence recorded by the magistrate. Could be on the basis of evidence recorded by the magistrate. Samples also should be sent immediately to the chemical analyzer so that subsequently a contention may not be raised at the
No, it speaks about drugs.
drugs only, my lord. But it recognizes the fact, my lord, that even in
NDPS case.
NDPS cases, 451 is applicable. So we revert, my lord, to para 15 onwards, my lord, for vehicles, my lord. And para 21 specifically, my lord, says that vehicles should not be kept in the police station for more than 15 days to 1 month, my lord. Now it has been more than 7 months, my lord. I am not an accused. This deals with, my lord, 0.98 grams of brown sugar seized from another person. My vehicle is lying there, my lord. Police does not want my vehicle, my lord. It is rotting in the police station, my lord.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 390, this application is under section 3401, read with section 397 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mozahar Ali, impugning the order dated which one is the second order?
My lord, page 41, 19/120.
Impugning the order dated 19/1
Page 41, my lord.
2024, whereby the prayer for Jimma made by the present petitioner of the vehicle, namely Bajaj Pulsar NS 125, bearing registration number AS 17M 4602, was rejected by the trial court. Learned counsel for the petitioner has submitted that on the basis of you have submitted FIR.
Yes, my lord.
Where is?
My lord, FIR is at page 22, my lord.
On the basis of an FIR lodged by one Utpal Roy, SI of police, before the officer in charge of Dhubri police station on 4/8/2023. Dhubri PS case number 305/2023 under section 21A, 21 within bracket small a /27 of the NDPS Act 1985 was registered. Stop. Ultimately, after completion of the investigation, the charge sheet was laid against one. Who is the accused?
My lord, Nasiruddin, Mizanur Rahman, and Zahirul Islam.
Against three accused persons, namely Nasiruddin,
Mizanur Rahman,
Mizanur Rahman,
and
and
Zahirul Islam.
Zahirul
Zahirul
Islam.
Hussain, my lord.
Zahirul Hussain. It is also submitted by learned counsel for the petitioner that the motorcycle belonging to the present petitioner bearing registration number
My lord, AS 17M 460.
AS 1746, earlier registration number, was also seized from the possession of
Nasiruddin.
one Nasiruddin, who was using that vehicle at that point of time. Stop. It is submitted by learned counsel for the petitioner that the present petitioner, namely Mozahar Ali, is not an accused in this case, and the he was not knowing that his vehicle was used for commission of an offense under section under NDPS Act. Stop. It is submitted that though on earlier occasions when the petitioner had filed a prayer for filed an application seeking Jimma of the vehicle, same was rejected by the learned special judge Dhubri on the ground that the vehicle may be required for the purpose of investigation, as at that time investigation was still on. However, thereafter, after full stop, however, thereafter, on 17/1/2024, the investigating officer had submitted a report before the Session Judge Dhubri, inter alia, mentioning therein that the seized vehicle is no longer required for the investigation of this case. Learned counsel for the petitioner has submitted that as the investigation has been completed and as the petitioner's motorcycle is lying in the Dhubri police station since
4/8/23.
since 4/8/2020 23, that is for last 7 months.
7 months.
The learned special judge has erred in not granting the Jimma petition, Jimma of the said vehicle to its owner, who is the present petitioner, in spite of the clear direction of the apex court in the case of Sundar Bhai Ambalal Desai versus State of Gujarat, repeated in 2002 10 SCC 283, whereby the whereby it was observed as follows, Code Para 21, 21 from the judgment. So I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor and have also perused the materials available on record. As quoted herein above, the apex court has observed that the seized vehicles should not be kept in the police station for a long time, and the powers under section 451 of the Code of Criminal Procedure should be properly and promptly exercised. However, in this instant case, it appears that though on the earlier occasion when the learned I'll complete the judgment order in the chamber. Your prayer is allowed.
Okay, I only
Deeply
want to
obliged,
state here, CD is not available in that case, Lordship. 113, Lordship.
We are disposing of.
Okay.
খালি চলো যাবে।
Yes, Mr. Bosho.
I criminal 179 2024. Other than from the lordship, from queries.
What is once this IS 666 for?
I triple six is not.
I triple six.
179,000.
I triple six for providing treatment for his eyesight problem, lordship.
He is already under treatment.
I triple six for providing treatment, lordship. Because he was suffering from eyesight problem, lordship. Going. Triple six to 2022.
So it is also pending.
That is direction passed by this honorable court, lordship, because there was no machine to operate his in his eyes, lordship. That is why, lordship, this appeal hearing was that has been heard by the court below, and subsequently that was released, lordship. But yes, after that, lordship, we filed this 179 because his condition is very bad, lordship. Right now, his position is
Yes,
uh,
yes, Mr. Bosho, 179.
It is very hard, but I like to bring to your notice. It is the conviction was 10 years. But somehow the objection was not filed from the side of the prosecution in this matter. I know Lordship is already.
That option has gone.
Yes.
There is no objection on record.
Yes, no. Record. And it is filed on 2024 dollars, not 2022 dollars. RD and medical. matter
why not?
dollars. And in that matter, Lordship, the medical
Okay, if I
report was
go so.
from the DMC that has already tagged with the file lots. If the medical report dated not 18 February 2020.
Actually, all orders are passed.
Confused করা গেল। Confused করা- This was filed in the month of January, lordship, and now, lordship, March, lordship, bail petition filed, but they have not filed the objection, lordship. After that, lordship has already taken up the matter, lordship, already heard the matter, lordship, on that part. Yesterday also they have not mentioned these things, lordship.
No, yesterday was the first day, I think.
Yes,
Yes.
but lordship,
In
this was
179.
filed. And then
Lordship.
yesterday they could have mentioned that thing that we have not filed that.
There are 3 cases. That it is in my part, that was a mistake I made. So that I apologize for that.
But because of that reason, lordship, person who is severely ill and several times he was admitted in the hospital because of that.
The statute provides that they have a right to file an objection. Otherwise, we could have disposed of it today itself. But yesterday we took up 179 for the first time.
Lordship, but that time it was his duty to raise these points, lordship. Already, lordship.
Because 6 was also there medical. I made a mistake, Lordship, that time. But I
Now,
think
what is your
admitted in
submit?
my part, Lordship.
What is your submission?
If a short date is given, I will file the objection in the time, if Lordship allows. Or otherwise, Lordship.
Lordship, his condition, lordship, aware about that thing, lordship, because and lordship. one
File
second.
tomorrow.
Day after.
Tomorrow they can file, lordship, if possible, then lordship may take up Friday, lordship.
Okay,
Considering the
because,
condition-
because this is their statutory right.
Exactly,
file.
but lordship, they did not apply that statutory right, lordship. They did not go for that. but right now already heard the matter, and in that case, considering the condition of
No,
the
yesterday
co-
you
co-
took the entire time.
lordship,
Today
considering,
is his,
my lord,
let him file tomorrow or day after tomorrow.
lordship, considering the health condition of the person, lordship, that is why, lordship.
Lordship, even
Only if
we go through
if-
the medical report, Lordship, there it is clearly stated that he is. Presently improving. Presently improving.
right now, the present condition, lordship, I have collect-
2024.
lordship, consider.
Now. it is
Kindly
the month
see,
of March.
kindly see these documents, lordship, present document, lordship, your family member provided us, lordship. Any question? Any question? সেইটো কথা বলো। এই কোৰ্টৰ ৰেকৰ্ডটো তোমাৰ 1 বছৰ আগৰ আছে। এনেকা নহয় দেই। He was admitted in unconscious condition in the hospital, lordship.
When?
On last occasion, lordship, when it was before your lordship, then thereafter, lordship, on last week also, he was admitted, lordship, he is in.
No, let him file the objection.
Can it be on Friday, lordship?
We'll issue direction for providing necessary medical treatment during.
That is fine, lordship,
And
only
we'll hear it on Monday. Let him also get it.
Monday is a holiday, lordship, Monday, Tuesday, Wednesday, holiday, that is why, can it be on Friday, lordship? There are
Then you
objections,
file on Friday, we'll hear it on Friday.
that may be called for also.
No, what is your difficulty in hearing the matter on Friday? You file on Friday, I'm giving you time. We'll hear the matter on Friday. Heard, Miss S.K. Nargis Nalla in 179, criminal appeal 17. S.K. Nargis, learned counsel for the petition applicant. Also on Mr. K.K. Bushaw, learned additional public prosecutor, who submits that the state respondent may be given an opportunity to file a written objection against the prayer for suspension of sentence made by the petitioner. Stop. He submitted that as there are as the case was tagged with another interlocutory application, that is IA 666/2022, hence he could not make this prayer yesterday. Considering on the other hand, Ms. S.K. Nargis submitted that the present health condition of the petitioner is not good. And in support of her submission here, she has produced certain photocopies of certain medical documents before this court. Considering the submissions made by learned counsel for both the sides, the state respondent is allowed to file written objection on latest by 22/2/2024. And on that date, the interlocutory application number 179 shall be heard and disposed of. In the meanwhile, considering the submission of learned counsel for the petitioner, the superintendent of district jail, where Guwahati, Central Jail Guwahati, is hereby directed to provide all necessary medical treatment to the petitioner during this period. A copy of this order shall be furnished to the Superintendent District Jail, Central Jail Guwahati by the registry forthwith. Let this case be listed accordingly on 22nd March 2024.
At 2, lordship, then that will be better.
Okay, at 2 p.m.
At 2. Obliged.
Item number 23. Not available in that case.
I pray for giving it pardon because Lordship have heard at the length, Lordship. Only the CD, only that specific one line submission will be there, Lordship. And other two, Lordship.
Why this was tagged with, it will
Because
otherwise,
of same case there in Lordship. With
same
that
police
case.
station.
Yes, that is what, that is what. Now earlier that item 22 was same, so.
No, why it was tagged with the item number?
21, Lordship, because same person was there, Lordship.
Same person does not mean that Lordship.
No, same person, one case was there, so we have mentioned it.
Okay,
like
I'm
that.
not mentioning anything, not mentioning anything.
No, only because of that, he, same person have two case, Lordship. It will come to your Lordship,
How Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that apart from the statement of co-accused, there is no other material on record to implicate the present petitioners, namely Muhammad Inamul Ali and Abdul Ali. Stop. Learned additional public prosecutor submitted that to consider the submissions made by learned counsel for the petitioner, perusal of the case diary would be necessary in this case. Hence, call for the scanned copy of the charge sheet has been laid in this.
Lordship.
Scanned copy of the case
It
diary.
can be some has come, Lordship.
No, of case diary is there.
No, kiba to record to agent LCR.
Only records are there, order sheets are there.
Scanned copy of the case diary of North Guwahati Police Station case number 111/2023 from the Court of Learned Sessions Judge Kamrup at Amingaon. The registry shall take steps for requisitioning the aforesaid scanned copies. Let this case be listed again on. Stop. Learned Session Judge Kamrup shall also furnish an up-to-date status report regarding the progress of the NDPS case number. What is the case number?
03, Lordship.
03/2024 pending in his court. Let this matter be listed again on 9th of April.
It will be, Lordship will capture the part of Lordship.
No partner.
Again,
If
we have
it-
to
if-
start from beginning, Lordship.
No,
It will cut out the type of code, Lordship. Only specific one, if connection is the other.
no, if it otherwise comes to this court, it is okay. Otherwise, I'll not keep it partner.
It will have to start from beginning, Lordship.
Beginning is not very far away.
Much obliged, your Lordship. Much ob-
Please, Lordship. Lordship, this case was registered under section 447, 506, 34 and under section 5 of the Land Grabbing Prohibition Act. Lordship. We have taken steps on the respondent number 2, Lordship, both by registered and usual ways. And finally, we have taken by paper publication, Lordship. Thereafter also she has not appeared. And of late, Lordship, so far as the plot of land in question, we filed a title suit, Lordship. So there we got the decree over the side of the plot of land. So as because we have got a declaration from the civil court, so we cannot be termed as a land grabber, Lordship. Otherwise, Lordship, the further proceeding of this case was stayed.
Now,
I have brought it by way of an additional affidavit, Lordship, judgment and decree.
we can hear it today, or you are ready? And regarding the respondent number,
Respondent number 2, Lordship, we have taken steps by way of.
whether any order is there that service is complete.
Lordship, on the last, in the last order, there is an indication, Lordship. But we have taken, as per the direction of this honorable court, we have taken steps by way of paper publication, Lordship. Because she is not otherwise traceable, Lordship.
Okay, then
Lordship, may fix a date for final hearing of the matter, Lordship, at the admission stage itself, Lordship.
now we'll fix it in hearing column if it is ready for hearing. heard Mr. D. Das, learned counsel for the petitioners. Also heard Ms. N. Das, learned additional public prosecutor. None has appeared for respondent number 2. It appears from record that service of notice on respondent number 2 is complete. Hence, this matter is ready for hearing. List this matter for hearing.
Lordship, can it be, I pray for keeping it in admission stage itself, on a date to be fixed by
No.
Lordship,
Why admission stay?
because the
It will-
hearing.
We may give a fixed date for
Yes.
hearing. Let it come in hearing column,
Lordship,
because
Then-
this has already been admitted.
it is not admitted yet.
Okay, the case is admitted for hearing. The,
So can it be on,
as this case is ready for hearing, list this matter for hearing on, yes, suggested date.
Lordship, on 28, Lordship, 28 of this month,
This month.
Lordship. Because why I'm insisting, Lordship, the petition number 1, she is having some medical condition, Lordship, because he's having the anxiety
Yes, Ms.
to.
Das, suggested date,
Athletic-
because petitioner is ready, but you are not ready. Third of April.
3rd of April, Lordship, 4th of April, I have some difficulty, Lordship.
Okay.
Then on 2nd of April, Lordship.
2nd of April,
Lordship.
fix this matter for hearing.
Lordship, there is an interim order that.
The interim order shall continue till next.
May please. So this is a petition filed against a rejection order at page 20. See what has happened before. Page 20, that you would see. There is no precise reason given.
What has been rejected?
Lordship, what has happened, I am an ex-serviceman. After my short service retirement, I was hired by the director of Nidhi Bank for as a personal security.
Director of?
Nidhi Bank.
Okay.
I have annexed agreement. Thereafter, I was the PSO, there was a driver. Now, during Durga Puja, Lordship, we put Birmingham in our pistols and I washed it and kept it in the dashboard. Now, while I kept it in the dashboard and I just went out, the driver picked up the gun and took a photo and posted it in the Facebook. Now, after some days, he left the service and was entangled in an NDPS matter. Now, when there was a background check, his Facebook account, I'll show the picture at page 34. His Facebook account showed the pistol like this. Now they inquired about the pistol. Now I have no way related with the case. My pistol has been seized from 2023 onwards.
You have license?
Yes, valid license. Lordship would see the picture first. At page 34. Page 34 is the picture. Now, Lordship, my license documents were
Page
from
33.
page 33, Lordship, yes. 33. My license documents is from page 21.
After seeing this picture, nobody would release the gun. After seeing this picture, it appears that the trial court was right in rejecting the prayer.
Yes.
Though you are the owner. This person is not the owner.
This person is not, he just picked up the gun which was kept in the dashboard. He was the driver of the vehicle.
Okay.
And clicked a photo and posted in the Facebook. Now, Lordship would see the agreement at page 34. What has happened now, without the gun, I get a 50% salary cap.
Where is the clause?
clause, Lordship, the 36.
No, gun was seized in NDPS case.
Yeah, no, later Lordship would see the FIR at page 12. Now, Lordship would FIR 3.12 grams of heroin was found,
Where is
With-
the FIR at page?
page 12. Uh,
Okay.
May I read? Lordship?
Yes.
This is to inform you that a reliable information was received from a source at 5:30 today for 4:12 that 3 boys are waiting for customer for selling something suspected to be drugs at Kerkusi near Hockey Stadium. The information was recorded in General Diary entry by Bosista PS DDA number 190 dated so and so by the OC Bokisto and directed that I along with following police personnel proceed to verify the authenticity of the information. The details so and so. Accordingly, I along with a police person left for PO in a departmental requisition vehicle bearing registration number so and so, which was driven by HG so and so along the investigation kit digital waiting scale towards Kerkusi on arrival at Kerkusi behind Hockey Stadium. As shown by the source, 3 boys apprehended and examined. During preliminary inquiry, they disclosed their names. So and so it was mentioned below witness who were working on Birinapot behind Hockey Stadium, Kerkusi, and requested them to state witness during the search, and they agreed. I identified before the witness as well as apprehended person. which is
3.12 gram of heroin was recovered.
recovered.
Okay. This was the FIR. How this arm came into picture?
Huh?
This pistol,
This pistol, there was a background check after the arrest.
it
Now-
was seized in connection with this case,
Yes,
or a separate FIR was lodged.
no, it's a connection with this case. Now, in his Facebook account, this was the profile picture. He was asked about the gun, where
Along
is-
with gun.
along with gun. This is the profile pic.
Okay.
One copy has. Gun is good.
Any case under Arms Act was registered.
No, Lordship. It was.
Okay. Okay, proceed.
No, Lordship. In connection with this case only. And in the Lordship, in the order also, Lordship would see that there is no such. I'll just read the order, second paragraph. As call for report has submitted by the IO of the case wherein it has been stated that the investigation is continuing in regard to the seized pistol along with ammunitions and other incriminating material as such the seized pistol along with and other materials are required for further investigation. This was a 2023. Now, Lordship, this pistol or myself has nothing to do with the case at hand, Lordship. Therefore, and I will make it ready at any time because this is a source of livelihood for me. Lordship. I have no criminal antecedent whatsoever.
Where is the seizure list?
At page 18.
Page,
Page 18, Lordship. Page 18. 1.32 pistol, civil, so and so. Indian Ordnance Factory along with 6 bullets in one magazine and 4
from
bullets in
whom it
another.
was seized? From your custody?
Yes, yes.
Okay.
They called me to the police station and I handed over it. And I myself is an ex-serviceman with no criminal antecedent whatsoever.
Where is the license?
License at page 21 onwards. What you would see. And this is 29, what you would precisely. 5/3/2023. Because of the seizure, I could not renew my license also.
But if it is not renewed, how can we hand over the custody?
Lordship, while renewal, Lordship, we have to
Produce the,
produce it.
now what is your submission?
Therefore, Lordship, I have nothing to do with the case in hand. It was just a coincidence where he took my pistol, clicked a photo, posted a profile picture. Then later he was arrested in a case. Now, Lordship, I have the valid license and I have, Lordship, I have filed an additional affidavit also saying that I have all the training to handle the arms license, Lordship. I have no criminal antecedents and moreover, Lordship, I fulfill the requisites of granting Gimma, Lordship. That's my submission.
Yes. What report? Regarding requirement of pistol in the investigation.
Lordship, I will produce it anytime day one with a condition. After retirement, this is my source of livelihood. Lordship.
And this pistol was not seized from the accused. It was seized from the present petitioner who holds the valid license. He will produce it.
And not seized, I went to the police station and gave them.
Heard, Mr. What is your name?
BP Bora. Lordship.
When can you produce the report? Let us call for a report, giving the
Lordship, report I think was called,
earlier, whether it was no report such.
was called for, I think. Lordship, I'll just check the previous orders. If Lordship takes it up after some time.
Or whether case diary is there. Because even through, by going through case diary, we will know.
Lordship, there is.
Yes, what is the submission?
Lordship, Lordship, we take condition that I will produce it anytime, Lordship, day one.
In your additional affidavit, what have you?
Yes, Lordship, in my additional affidavit, I have, Lordship, there was one query whether I can hold the license or not. So I brought in the rules that I, in terms of giving a license, the defense personnel are get a priority under Rule 13(3). Moreover, Lordship, I have also brought in record at page 45 all the certificates.
Okay, heard, Mr. What is your name?
BP Boral.
BP Bora, learned counsel for the petitioner. This interlocutory application is for what?
Lordship, this interlocutory application was for the investigation officer to be implemented. Therefore, Lordship, I just filed it. I thought it at that time it was necessary. Therefore, I
Also heard Miss N. Das, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Bonful Deka, impugning the order dated 21/2023 passed by learned additional session judge within bracket FTC number 3, Kamrup Metro, in Miss Case number 172/2022, whereby the prayer for Jimma of a pistol which was seized along with ammunition in this case. Ammunition in which case?
Lordship, PS case, page 12, Lordship. Yes. Case number NDP 1035 under section 21A29. Bokista PS 10335. FI number and case number.
In connection with Bashishta PS case number 1035/2022 under section 21A/29 of the NDPS Act. Stop. The learned counsel for the petitioner has submitted that on the basis of an FIR lodged by one Shri Mukundo Sharma, SI of Police of Bashishta PS, before the officer in charge of Bashishta Police Station, inter alia, alleging that 3.12 grams of suspected heroines was recovered from the possession of three persons, namely Shri Vicky Sonar, Shri Sanjay Kumar Shah, and Shri Dipankar Bhuya. The Bashishta PS case number 1035/2022 was registered and investigation was initiated. During the course of investigation, the petitioner was summoned by the investigating officer, and he appeared before the investigating officer along with 0.32 pistol. What is the civil INGSF 2103058 capital LLO.32 of Indian Ordnance Factory, along with 6 bullets in one magazine, 4 bullets in another magazine, and 28 bullets with bullet carrier and pistol holder, and 2 blank cartridge. On production of the said arms and ammunition before the investigating officer of the Bashishta PS case number 1035/2022, the investigating officer seized the said arms and ammunition from the custody of the present petitioner on 13th of December 2022. Stop. It is submitted by learned counsel for the petitioner that who is the accused? Mintu
Vicky
Mishra.
Sonar.
Who is the accused who?
Vicky Sonar.
Vic-
Vicky
Vicky
Sonar,
Sonar.
Lordship, page 12.
How you came to?
Lordship, he was a driver of the vehicle of Rituparna Pathak, that is the director of the Nidhi Bank. I was the PSO.
Learned counsel for the petitioner has submitted that the petitioner is an ex-serviceman, and earlier he was you were in,
Indian Army, Lordship.
earlier he was serving in Indian Army. After retiring from the Indian Army, he was engaged in as an PSO
Of Rituparna Pathak, Director, Nidhi Bank.
of the director of the Nidhi Bank. There he come in acquaintance with accused Vicky Sonar, who is the driver of the,
He was appointed as driver.
who is the driver of the vehicle of the director of Nidhi Bank. It is submitted, where have you made the statement that he took your
Yes, yes.
pistol from the dashboard?
Yes, yes.
Where is this?
Page 6. Page 6, Lordship, 3, that the accused person has used the arms of the petitioner just to click a selfie and post it in the Facebook account. Page 3 also. But I'm sorry, it's Mintu Mishra. He is not named in the FIR. It's Mintu Mishra. He was also arrested in connection with this case. Lordship, it's not Vicky Sonar, it's Mintu Mishra. I am not the named FIR.
Mintu Mishra. Mintu, instead of Vicky Sonar, name Mintu Mishra.
And para 3 also.
Who is not the named accused in the FIR.
No, and page 3 also I have stated that the accused Mintu Mishra was appointed as a driver of Rituparna Pathak. On the day of Kali Puja, the petitioner offered prayers and also as a matter of tradition put sindoor in his arm. So and so the petitioner rubbed his licensed gun with water and kept it to dry in the car of Rituparna Pathak. The accused Mintu Mishra, who was the driver of the car.
It is submitted by learned counsel for the petitioner that on the day of Kali Puja, after offering traditional puja to the arms, the petitioner kept the pistol on the dashboard of the vehicle of the director of the Nidhi Bank. And during this period, the driver, that is Mintu Mishra, took the said arm and took a selfie and post that selfie as his display picture in his Facebook account. And therefore this pistol got entangled with the case, that is
PS case 103.
PS case number
1035/2022.
1035/2022. Learned counsel for the petitioner has submitted that as the petitioner is you are the owner.
Yes.
As the petitioner is the owner of the seized arms and ammunition, and he is presently, where is your contract?
Yes, contract is
Where-
page 34, Lordship.
Where is the clause that
Yes,
you have?
yes, till 2025 it is there. Page 35, Lordship would see first paragraph only. With effect from 1/10/2022 to 39/2025.
No, that clause that unless you have that of this,
Lordship, that is my instruction, Lordship, because these circumstances has happened. So it was the arrangement made by his owner that till the arms, he gets the arms, he will be paid half of the amount. That is my instruction by my client.
no clause is there.
Not closer, because such an situation, we could not foresee that it can happen.
What was this? He is presently engaged as a PSO with Nidhi Bank, as a PSO of the director of the Nidhi Bank, unless he carries his arms, his would livelihood would suffer. It is also submitted by learned counsel for the petitioner that he is in no way involved in the offense which is alleged in the FIR, on the basis of which Vasishta PS case number 1035/22 was registered. It is also submitted that the petitioner has all the trainings to use and carry the said arm. And to this effect, he has also submitted an additional affidavit in this court.
Page 45 is my certificate.
Learned counsel for the petitioner has also submitted that the petitioner would produce the said arm as and when so required for the purpose of investigation. Stop. What is your submission? No, we are disposing of this matter. I have considered this, I have considered the submissions made by learned counsel for both the sides and peruse the materials on record. Apparently, from the materials available on record, it appears that the petitioner is in no way involved in the offense which has been alleged in the FIR, on the basis of which Vasishta PS case number 1035/22 has been registered. It also appears that only because of the display picture which has been posted in the Facebook account of the accused, what is his name?
Pintu Mishra.
Pintu Mishra, the investigating officer is investigating the link, the fact as to how Mr. Mintu Mishra got the said arm. As the materials available on record shows that the present petitioner is an ex-serviceman and presently working as a PSO at Nidhi Bank and is under contract to work as PSO there along with his arm, and also carries a valid license of the said arms. This court is of considered opinion that the impugn order is required to be interfered with, and accordingly interfered with. Stop. Accordingly, it is hereby directed that the
In the seizure list, it is there. A 0.32 pistol, serial number 1.
no, you go to the additional session judge. She will impose conditions.
Okay.
Accordingly, the additional sessions judge within bracket FTC number 3, Kamrup Metro, is hereby directed to give the Jimma of the seized arms and ammunition to the present petitioner on imposing conditions which the said court may deem fit and proper in the facts and circumstances of the case. The petitioner may also be directed to furnish a bond to produce the seized arms and ammunition before the investigating officer or before the court as and when so required. With this observation, this criminal petition is hereby disposed of. Let a copy of this order be sent to London Additional Session Judge number 3, Kamrup Metro, Guwahati for compliance.
Deeply obliged.
The, in view of disposal of the, in view of disposal of the criminal petition number 291/2023, this interlocutory application has become infructuous and accordingly disposed of.
Deeply.
In this case, I am appearing for the informant. I think the lordship just called for the scanned copy of the LCR. I think wrong records have been.
LCR is in.
The number is same, the year is different, my lord. Our case is of 22, I think the LCR of 20 has come.
Oh, yes, PRC case number 2020. Who are the parties?
I'm for the informant there for the.
I'm
petition.
a petitioner, Your Honor.
Name of the parties are? Who is-
One second.
Saradindu Chakravarti, Lordship.
Ranjit Bejborua is not a party.
No,
Heard Miss
Edas.
A. Das, learned counsel for the petitioner. Also heard Mr. K. N. Chaudhary, assisted by Miss R. Kakoti, learned counsel for the informant, as well
and
as
for the respondent number 2.
learned counsel for respondent number 2.
Yes.
Also heard Ms. N. Das, learned additional public prosecutor. It appears from record that the trial court record was called for by order dated 22/11.
Scan copy.
Scan copy of the scan copy of the trial court record was called for. However, it has been pointed out by learned senior counsel appearing for respondent number 2 that the scan copy which has been sent to this court has been wrongly sent off a different case, that is PRC case number 1350/2020, whereas the record which is relevant in this case is PRC case number 1350/2022. Let the registry issue again fresh reminder for requisitioning the scanned copy of the PRC case number 1350/2022 from the court of
Additional CGM, Lordship.
Guwahati,
Lordship.
Additional Chief Judicial Magistrate Guwahati. Please this matter
After receipt of the record.
Short date.
after 2 weeks.
Make please, Your Lordship. My lord, this is a case for quashing of the FIR, Lordship, which was filed under Prohibition of Child Marriage Act and along with POSCO Act, Lordship. Though there is no Lordship, she is a major victim
daughter of the petitioner. She is a major lordship duly married, and her statement 161 is also their lordship. In the LCR scan copy is their lordship. What is the use of that, my lord? Apart from, let me submit. Apart from that lordship, she have the birth certificate. And on the face of the FIR, as well as the lordship charge sheet and her birth certificate, lordship shows that there is no such case is their lordship for criminal any consequences in this regard, lordship. So my restricted submission, it is nothing but an abuse of the process of the court, just to harass and humiliate the petitioner, lordship, along with his son also, who is a student, lordship. His future career is in dilemma, lordship, if this case is pending before this.
No, no, what is your submission?
My restricted submission, she is a major, lordship,
He is a major, therefore POXO is not applicable.
not only POSCO, lordship, apart
The
from
Child Marriage
pro-
Prohibition
prohibit-
Act is also
lordship,
not applicable.
lordship. And there is
Whether
no
charge sheet has been laid,
lordship charge sheet.
then on what basis charge sheet was laid if you are major?
Lordship, I am challenging that charge sheet also in my writ petition. And there is also judgment, lordship, that there is no bar. This honorable court can quash the entire proceeding, lordship. Because charge sheet, lordship, this charge sheet is totally false, lordship. Without perusing the birth certificate, lordship, counting mathematical calculation is there, lordship. Her birth certificate I have annexed on that also, lordship. And her statement 161, she has stated, lordship.
What is the date of birth?
Her date of birth is, lordship.
What is the name of the victim?
Victim name is, I am coming, lordship.
Tabassum,
Lordship,
Tabassum Akhtara.
Tabassum Akhtar. Her birth
Date of
certificate
birth
is
is
page 24, lordship.
31,
31/12/2004, lordship.
when the FIR was 22.
23, lordship. Original copy is there. Original copy, page 27, lordship.
Page 27
Of my writ petition, lordship, sorry, on my petition, annexure 5, lordship. Translation copy I have given, lordship. Vivahe,
page number
page 27, lordship. Annexure 5, lordship.
27 is the
Registration,
what is this? Marriage registration form.
registration certificate, lordship. And also there is also marriage and divorce register. Huh? Page 25 is the copy of marriage and divorce registration.
No, we will, these are your documents. Our
Lordship.
documents relied in the charge sheet also.
Lordship,
These are documents on which the IO relied.
lordship. Her 161 statement may kindly peruse. I have given flag mark person, lordship, for convenience of this honorable court, lordship. Because the victim, lordship, she is the major, lordship, in that day. And as per section, lordship, section 2A, lordship, of the Prohibition of Child Marriage Act shows that, lordship, the child means a person who, if a male or has completed 21 years of age, and if a female has not completed 18 years of age, on the day of marriage, lordship, and the allegation, lordship, the person is a very peculiar things, lordship. He is not well or past, lordship. He filed an FIR from 21 kilometers away from our residence, lordship. Subsequently, we came to know. We have no idea of that, lordship.
Yes, Miss Das, you.
And section 19.
For informant, you are appearing. You are not opposing the case of petition. You are opposing. Okay. Then there will be a hearing.
Lordship, no problem. If she is opposite party, lordship, complainant, lordship, whether what's the stand of the complainant?
Complainant or victim?
Not victim.
Complainant, okay.
Complainant, FIR, lordship, who has lodged the FIR, lordship, kindly consider that aspect, lordship, how he can lodge the FIR.
Before going ahead, whether Miss Das, you are ready? You are ready? We can hear and dispose of this matter. Yes, Mr. Yes, proceed.
FIR is page 17, Lordship.
You are challenging the FIR as well as
Charge sheet, Lordship.
charge
Lordship.
consequential proceedings.
Lordship.
Okay,
Because Lordship, it is nothing but an abuse of the valuable time of the Honorable Court, Lordship, nothing.
and
will
your
happen.
plea is that the victim was a
Major.
major
Lordship,
and the birth certificate shows that.
Lordship. Only that,
This,
Lordship.
this much is your.
Lordship, cracks of the submission of my that Lordship. Lordship, the FIR shows, Lordship, that the one thing just I am showing, Lordship, page 16, Lordship, date of information received 5/2/2023 at 9:50, Lordship. Page 16, Lordship. How the things, Lordship, FIR, filing the FIR, Lordship, information received, date of information received on 5/2/2023 and FIR, Lordship, page 17. Page 17, dated 6 February 2023.
So the form has been casually filled up. Okay. That is in column number 3C.
Lordship, 3C, Lordship.
3C, date is 5.
Not only that, Lordship, column number 1 also, they have mentioned it 5/2/2023. First line, Lordship. FIR number so and so, 5/2/2023. Then, Lordship,
However, in the written FIR, the date is mentioned as
page 17, dated 6 February 2023.
yes. Yes, Mr. Majumdar,
Lordship,
proceed.
that just I am not much taking time, Lordship. Just FIR shows, Lordship, I would like to inform you that the Nurul Haq so and so has one 17 years old daughter, which is not correct, Lordship. As per date of birth certificate, Tabassum so and so. On that time, victim was minor, and the fact came to my knowledge when I inquired about the matter locally.
Date of marriage is
Date of marriage, Lordship,
11/23. 17/11/23.
Lordship. 2023, Lordship. That is 8/2/2023 certificate was issued. Then, Lordship, and that time later, I also got to know that the victim was forcefully so and so, 9 years older than her, in lieu of the money which was offered to her parents. Lordship, he is a head assistant of a school, Lordship. They have no such things as their, Lordship. Just making an FIR story, Lordship. In that days, Lordship, that things was going on in Assam, Lordship, entire Assam. All the family members of the grooms of the victim clearly knows that the victim was minor, and when she has been forcefully married, so and so. Then all the accused, the present petitioner is the father, Lordship, petitioner number 1, Nurul Haq. And petitioner number 2 is the brother, Lordship, of the victim, Lordship. Ehsanul Haq, aged about 20 years. Then they approached this honorable court, Lordship, for anticipated bail, and petition number 2 was also arrested, Lordship. Then this honorable court granted pre-arrest bail, Lordship, page 21, Lordship.
Okay.
Then it was makes absolute, Lordship. Then the page 24 is the birth certificate, Lordship. Her date of birth is 31/12/2004. Then next one is the marriage or divorce of registered.
This birth certificate is available in the case diary also, or a separate, different birth certificate? Record to the. We have to go through the case diary.
Lordship, because LCR scan copy was called for last occasion, Lordship. Entire records was called for Lordship.
Whether case diary is there or not.
I think their Lordship. Her statement 161 statement is also their Lordship. 161 statement is there, right? And scan copy entire record is the earlier
No,
occasion,
entire PRC case record.
Lordship, entire record.
No, but to
Case diary, I think,
to
Lordship,
appreciate your submissions,
Lordship,
to
Lordship.
consider your submissions,
Lordship.
we would require the case diary.
Lordship, I think.
If it is there, we will go ahead.
Yes, yes. Case diary, I think with my learned friend will show Lordship because I've verified Lordship, the case diary, I think, with the records of that Lordship.
Okay.
161, all the statements are there, Lordship. Otherwise, the case diary. Because 161 surplus. It was 161.
Where is the birth certificate?
Birth certificate, page 24, Lordship.
Date of birth is 31/12/2004.
An Aadhaar card. Every record is there, Lordship. School certificate. Birth certificate is this.
What is the date of birth?
31/12/2004.
Is it
Yes.
the,
Yes, Lordship. Record is there, Lordship. Birth certificate in the case diary.
okay. Then by calculating this date
18 years,
as
9 months.
on 17/11/23, what would be the age?
Lordship, I calculated it, Lordship, the date of marriage is 10/1/23. That is 18 years, 7 months something, Lordship. As
Date of
per my
marriage is-
calculation.
Date of marriage is 17/11.
23, Lordship. No, date of marriage is तारीख of विवाह है সেই तारीख लिखिबो 10/1/23 ना.
As per 161 statement, Lordship. She stated that.
No, before that, what is the date of marriage?
Marriage is 10/1/23, Lordship.
From where you are saying that?
It is in the marriage registration certificate, Lordship. Page 27. It's in vernacular copy, Lordship. And also certificate.
But at page 25, annexure 4,
Lordship, it is registered on 8/2/23.
it was registered later on.
Lordship. And it is a Kazi registration, Lordship. 27. Normally on the day of
And 27 is
27 page, it was mentioned, but it was registered on 8/2/23.
so till 10/1/23. What was her age?
Age, Lordship, I calculated, Lordship. What is it? All of them next to us.
Not available.
As per marriage certificate, as per calculation, Lordship, 18 years, 7 months something, Lordship, I have counted, Lordship. Though I am not mathematically so strong, Lordship. In mathematics,
If you are not strong in mathematics,
Lordship.
then should I rely on your submission or not?
Lordship, with all fairness, I am submitting, Lordship. Sometimes I leave it to Lordship. Lordship may verify Lordship. The age 18 years, more than 18 years. With all respect, Lordship.
Okay, okay.
With all fairness, I am submitting what is on the record, Lordship. I cannot improve. But my respect to submission,
So
It
your
is-
main crux of your argument is that as the victim was major,
Lordship,
neither POXO Act would be applicable nor child
Ca-
marriage prohibition. Act.
Lordship, Lordship. This is my only crux of that, Lordship.
What is your submission?
This certificate, marriage registration certificate is not available. in this case. If, when it comes to as per the video part function. Page 24. 31 plus 2020. Okay, so 114.
17 years?
One.
No, 18 years. 18 years. More than 18 years. My elder sister is also not counting it. More than 18 years, Lordship. So this act is not at all applicable in my case, Lordship. It is a clear case of
Yes, yes. Yes,
Yeah.
yes, yes.
Which says, I that one some source as 117 was supposed to be married to a man who is about 26 years old, some source. And I got to know that the victim has been married on 27/11/2023. And on that time, the victim was a minor. This fact came to my knowledge when I inquired about the matter. Later, I was got to know that the victim was forcefully.
27 everyone hold out the measure.
Then in of
Bull.
money, which was offered for payments. Further, it's also done that the marriage took place in a traditional manner, in presence of relatives of both the victim girl and the groom. All the family members and group of the victim clearly know that the victim was minor when she has been forcefully married. The person namely said to be directed and directed to
Very sad.
parties and the
Rate
marriage.
of birth little minus करा.
So here this person, the involved in this affair, he is not talking about the contractual aspect of the marriage. He's not talking of the agreement. If your lordship will just see here, it's written in a traditional manner, which means he's talking about the social marriage. Your lordship, found it?
No, Muslim marriage, how it is for,
And also, since my learned senior has said that in paragraph 12 of the petition, my learned senior has done a very meticulous calculation of the age.
Vera? Page number?
Paragraph
Page 12. Okay.
My lordship, this calculation is based on a typographical error in the FIR. Because it is very apparent on the face of the FIR, since it was filed on 6/5/2023, the marriage couldn't have occurred on 27 November 2023, which is clearly a typographical error.
Okay.
In the same breath, if I believe that to be true, then even.
Now, what was the date of marriage? Because in this case, charge sheet has been laid. Investigation was done. Assuming that some wrong date has been mentioned in the FIR. During investigation, correct date could have been found out. So what was the correct date?
I'm not aware of the correct, but I'm just saying by the details given in the FIR.
Okay.
When the informant came, he has said that he came to know of the social match, and he's not spoken about the contractual, which was done in presence of the family. members.
18 years is there. More
So
than
your lordship, going by that part, because he's talking about the social marriage. So as on that day, the
Social marriage and on 27/11/23.
Yes, lordship, but it's very apparent that because he's talking about an offense which has already occurred. And this.
No, then why should we believe the first informant?
Yes, your lordship, so if I would like to point out, so this is just a categorical, because my learned senior, please turn to page 15, which is the affidavit sworn by the petitioner. The quashing of this FIR, which has been filed on 6/10/2023, and this affidavit has been sworn on 9th day of November 2022. That is what has been given.
Yes,
Yes, your lordship, so it is very apparent, sometimes typographical errors do occur. So we have to also get the benefit of that doubt. Because when the informant came before the police, so he's come about.
no, on this aspect, you may be right, that there may be a typographical error in the FIR. But as the lodging of FIR has been followed by an investigation, and he came here for quashing the charge sheet.
Yes.
So we have to take into account what was found out during investigation.
But I'm really going by this FIR.
And going by FIR, it appears that the first informant is not a reliable person because when he's lodging an FIR, he has not mentioned even the date correctly in the FIR.
Even your lordship is up, because even in the local courts, the charge sheet, the entire pre-trial memorandum
Okay.
also has copy pasted.
No, is there anywhere during investigation, any statement that I made a typographical error in the FIR, or is it your submission? But if there is a typographical error, the first informant could have made that statement before the IO, that while filing the FIR, I made a typographical error in the FIR. So you go through 161 statement of the first informant. What he has stated you go through.
Your lordship, the only reason why I'm bringing up this point is because my learned senior has pointed out in the petition, on the basis of this date, he's made the calculation that the
Yes,
victim was 18 years, 11 months and 20 days. So it is.
not on that day.
Not on
Yes, your lordship.
Date of marriage, which is there
There
in
for
the
marriage
annexure 5, that is,
By the date of marriage, minor could never be 18 years, 11 months.
no, Mr. Majumdar,
Lordship,
what would be the age of the victim as per the date of marriage shown in the marriage certificate?
Lordship, 18, more than 18 years,
18 years.
10 days.
Okay,
So
okay, let her finish. Yes.
Question, if it's specifically mentioned here, Lordship, may I just read the paragraph 14 and referring
Of the,
of the petition,
okay,
that the petitioners, may I,
yes,
that the petitioners beg to state that under the facts and circumstances of the instant case, the petitioners have no any specifically action to implicate the petitioners. It may not be justified if the petitioners are no more trial, since the allegation in the FIR are informal and omnibus allegations may not implicate the petitioners. Since the date of alleged marriage between daughter of the petitioner was mentioned in the FIR as 27/11/2023, while the date of birth of the victim as per birth certificate is 31/12/2004. As such, a mathematical calculation, the total age of the victim is 18 years, 10 months and 27 days. So my learned senior has come up only with this contention that on the basis of the date of marriage given in the FIR.
she is a major. As per that,
Yes, and it's framed for the FIR to be closed. So it is their own submission. Lordship. And it is apparent, it is a typographical error. How could you talk about an incident which has not yet occurred.
No, I have understood your submission. That assuming this to be a typographical error. Now we have to find out what is the correct date of marriage. That could be easily ascertained from the documents available on record.
Lordship, regarding the marriage certificate, there is no such document. That was- We have to call for the applicant.
The statement of the witnesses. What is the date of marriage
Uh,
of the prosecution witnesses? What is the date of marriage?
is lordship.
R 161 statement, victim statement is there. 161 statement is there.
No, when
The word Viva Policing. No, but date is not mentioned here.
whether marriage certificate was seized during investigation. Then we will require the case diary.
Lordship, my learned friend, what record is there, Lordship? I have no objection, Lordship, is the case diary, but whether these,
No,
these
to
are the
verify your
scan
submission,
copies,
to verify the,
scan copies,
even to consider your submission,
Lordship.
the case diary would be required.
Lordship, the,
On what material the IO relied upon to file
Lordship,
the charge.
just I am,
I have understood your submission.
Lordship,
Birth date is there, marriage date is there.
Lordship.
You have to calculate.
Lordship.
If the victim is minor,
And
Your
as per
case
Juvenile,
works.
POSCO Act will not come on the way as per Juvenile section 94, Lordship, date of birth as per school certificate is section 94(2), Lordship. The
okay.
honorable
No,
court
but
is to,
now we
the
don't have,
POSCO Act will not come on the way, Lordship,
but now we don't have materials to verify
Lordship.
unless we have case
I
diary.
have annexed all these documents, Lordship.
But
and
these are your documents.
I have no
Don't-
objection, Lordship, let it be remain part of Lordship. Because so long your Lordships has already heard the matter, Lordship, I do not,
When can you produce the case diary? Which court?
it's from Hojai, Lordship.
Heard Mr. K. A. Majumdar, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor, as well as Miss
Scan copy as well.
M.K.
Scan copy also.
M.K. Brown, learned counsel for the informant, that is respondent number 2. The hearing remained inconclusive. During the course of hearing, it was found that the scanned copy of the case record which was called for does not contain complete case diary of Hojai PS case number 81/2023. And to consider the submissions made by learned counsel for both the sides, perusal of this case diary would be necessary.
Lordship, it is a special POSCO 72 of 2023.
No, yes. Hence, call for the case diary of, call for this scan copy of the entire case diary of Hojai PS case number 81/2023 in connection with corresponding to, what is this corresponding to?
Special POSCO
POSCO
case number 72 H of
72H
23.
of 2023 from the Court of Learned Special Judge Hojai. The registry to issue requisition for calling for the case diary from the Court of Learned Special Judge Hojai.
In the-
Let this case be listed again on
Lordship,
21st. 22 तारीख और आगे तक। On 19th April.
Lordship, in the meantime, may I pray, Lordship, the further proceeding before the learned court will or special case, Lordship, may be suspended, Lordship. Otherwise, Lordship, there are also, Lordship, some problems is there, Lordship. They will have to appear of everything, Lordship. I pray, Lordship, since all the records have been called for, Lordship. And apart from that, All right, since the record has been.
Fixed on 19th of April, 2024.
24, as part of
Stop, as part of matter, stop. Considering the submissions of learned counsel for both the sides, the further proceedings of
special
Would-
POSCO case number.
special POXO case number 72H/2023 pending before the court of learned special judge Hojai shall remain suspended.
Lordship.
List accordingly.
Apart from that, Lordship, there some judgments are there, Lordship, only based on FIR as well as charge
On
sheet,
19.
Lordship. That, all right, since the record has been called, Lordship, I have no objection. It should be part of, much obliged, Lordship.
Item 16.
As per the last order, CD has been called and today is listed for consideration of the interim period, Lordship.
Notice on respondent number 2 has been served. Engage counsel for respondent number 2. Let him come prepared.
Lordship, I just like to inform you that I have appeared and complied the 41 notice also.
Okay. Now it is still under investigation stage.
Still under investigation. Either they
Investigation.
will file the final report because once we have been called, we have
And
participated.
you are on bail.
No bail, Lordship,
You have not been arrested.
not yet arrested.
Okay,
We have participated in the proceedings.
okay. Heard Mr. A. Kakoti, learned counsel for the petitioner. Also heard Mr. A.B.T. Hawk appearing on behalf of Mr. U. Datta, learned counsel for respondent number 2. Also heard Ms. N. Das, learned additional public prosecutor, who submits that she may be allowed some more time to produce the case diary of Silchar PS case number 1880/2023. Stop. Mr. A.B.T. Hawk also submits that Mr. U. Datta could not appear before the court today due to personal difficulties and and has prayed for adjournment today. Considering the when can you produce the case diary? Considering the submissions made by learned counsel for the petitioner, the case is adjourned for today. The hearing is adjourned for today. Let this case be listed again on 10th of April 2024 for case diary.
Some interim relief may be granted till next day, Lordship.
What interim relief?
No coercive action.
No, coercive action has
We have
otherwise
already
not been
participated.
taken
We have already participated in the proceeding.
on 10th.
Deeply upset.
May I please, Lordship? Lordship, this matter, Lordship, relates to Lordship, Jimma, Lordship, Jimma of some non-boiled rice, Lordship, 460 bags, Lordship. So it is, Lordship, immediately it was recovered, Lordship, seized from my possession, Lordship, from my godown. So, Lordship, but while Lordship, I approached before the court below, Lordship, my Jimma petition was rejected, Lordship. Lordship may have, for the first time, Lordship may have the seizure list, Lordship, for the first time, Lordship. This
Where is the
immediate
impugn
position,
order?
Lordship.
Where is the impugn order?
Yes, impugn order, session judge order is Lordship, page 44, Lordship. There is two orders impugn here, Lordship. The SDGM passed first order, Lordship, there is rejected, Lordship. And thereafter I filed a revision petition, Lordship, and revision order is page 44, Lordship.
Page
44, Lordship. The relevant portion will be, Lordship, page 47, Lordship, and 40.
50 also lordship, 50 will be the most relevant lordship. Paragraph 12. Your lordship, it is only says that,
Yes,
lordship, page 50 will be more relevant lordship, where the, on what ground lordship my petition was rejected lordship. Paragraph 12. This is the findings of the session judge lordship.
yes.
Yes, lordship, the ground is only says that there is the, I am not the legal honor lordship. There is the,
I am taking 2 minutes short break.
it is
You
also
failed to
included.
produce any valid documents.
Yes, lordship.
So, and anything else?
And lordship, another point is said that since article is already lordship directed to be sold in a public auction lordship.
Or
So this court lordship declined to interfere in the order of the trial court lordship.
who issued that direction for?
And
sale?
in the trial court lordship, first lordship, before I approaching the court lordship, the court
That
already lordship, at
direction was-
party basis lordship, the given IO lordship.
Till now, it has not yet been sold.
Yes, lordship, not sold lordship.
How we will come to know?
Lordship, it's, I know from the police station lordship, it is still it is their lordship.
Why, in spite of the directions of the court, why it has
Yes,
not?
there is also their failure of their part lordship. Even there is no stay order, then they,
And otherwise, what is your submission? How to counter the observations made by trial court in the
lordship,
impugned order?
counter is their lordship. First lordship, I am the honor lordship. My, although I have no parcels received lordship, I have explained in my petition lordship from the court below lordship, that since I am a businessman lordship, I am a rise businessman lordship, I have the record here lordship. And lordship, my part is that lordship, I used to sell in the market lordship, and again lordship, whenever lordship, I get some rice lordship in separate lordship, then a parcels lordship from the villager lordship. So this rice lordship, their lordship, the local people lordship, they sold in the open market lordship. Some are come 5 kg, some are sold it 10 kg. It is like this lordship. So I collected lordship from the lordship. So they have no any receipt lordship. So they did not give the receipts. That's all lordship. Again I purchase. Again I lordship necessity. I sold it.
How
in the
much rice?
lordship?
How much rice?
Rice is lordship now 460 bags lordship. And there is my godown also there lordship. And I keep whenever it remain lordship, then I keep in the godown lordship. So this is my business lordship. In this record lordship,
And what is the allegation in this case?
allegation lordship, this rice may be the stolen property lordship. This is the allegation lordship. And on the basis of the allegation lordship, my whole article was seized lordship. And seized was from my position lordship. So till then lordship, nobody approached the authority lordship that this rice may be their lordship. So only I am the person lordship, then I can show that this was recovered from me lordship, or this was seized from me lordship. So seizure list may be lordship, or market committee lordship give to certificate lordship that I am a rice seller lordship. That is page 16 is their lordship. And vernacular part is
No, let us read para 11 of the impugned judgment.
yes, lordship. No, this is this lordship out of the background of the case, no, something is not in the reflected in the order lordship. Even the lordship, I am coming to that lordship.
Not produce any valid document in respect of the sales rights. Lordship,
Yes.
sales rights, and that they also clarify that the petitioner has not purchased the sales rights from the government or non-government institution.
That is correct. I have not purchased from the government institution.
From
That is
where
correct.
you have purchased this rice?
No, lordship, I am saying I am purchased from the public lordship. They public lordship, some of them lordship, they do not want to that non-gold rice lordship. That's why they sell it in open market lordship. And I purchased from the open market lordship. That villager also admitted that lordship. That may lordship.
Okay.
Yes, lordship. Here is
Without
the
any cash memo.
cash memo is not, but they have the writing lordship. They given a writing to the police station lordship. When my rice was seized lordship, on the day lordship, the villagers gave a writing lordship. Lordship may have, for a moment, lordship have this page lordship. There are many villagers is there lordship. Page lordship in Assamese version lordship, I am reading page 22 lordship. Vernacular portion lordship. There is a
Page number?
22 lordship. It is vernacular portion lordship. Type copy was the signature is their lordship in page 23, their lordship, several persons are their lordship. It is only on the day itself lordship, this person lordship they admit it. Because they do not like to eat that rice lordship, that's why they sell it open market lordship.
Then by which order it was directed to be sold?
Yes, lordship, this aspect lordship cannot be considered by the court below because lordship prior to lordship, I am appraising the court lordship, the trial court already given the direction to the IO lordship to sell it lordship. Prior to I appraising this.
So if that order remains,
Yes, the order is same in lordship.
no, my query is, if the order by which the rice was directed to be sold,
So
if that order is not interfered with, how Jimma can be given to
yes,
somebody?
that order was challenged in the session court lordship.
You have challenged that order.
Yes, that order was challenged lordship.
And what happened?
There is the order lordship, session the order lordship, they said that, session order said that no, there is no matters to interfere lordship. Because lordship, I could not produce any valid.
You have challenged the directions given by the trial court
Yes.
for selling the rice
Yes, lordship, that order was
before
challenged.
sessions court.
Yes, lordship.
And in that, your prayer was rejected
Yes, lordship,
and your Jimma prayer was also rejected.
rejected lordship.
Okay.
This was the lordship. So that order is also under challenge lordship. In my case, lordship, while I filed the Jimma petition lordship, that this order was passed lordship, page 28 lordship. This simply said that it is already given direction to the IO to sell it lordship. So it is not, now it cannot be given to Jimma to me lordship. Page 28. This is only said lordship in view of the above so and so. So I have before the session court lordship, I have challenged also this order also and the order of the lordship, the trial court order lordship. The trial court order is lordship page. And that lordship I came to know lordship after that lordship. Page 30 lordship, that is the order of the trial court lordship. It was given ex parte basis lordship. Without hearing me lordship, without giving any opportunity to me lordship, this order was passed lordship. Only simply lordship, I give a prayer lordship that I cannot accommodate this rice, so it can be given permission to sell it lordship, and that's why the order was passed lordship. It is prior to that lordship.
The legal order of the rights could not be accepted.
Could not be accepted. They have the investigating authority. They may lordship, whatever signature I have given lordship from the public lordship, they may ask them lordship whether they sold it to me or not lordship. They can ask lordship. And if public lordship at all lordship, they vehemently deny, though no, we did not sell it. Then lordship, he can ascertain lordship, I am not the owner lordship. And if public says, yes, we sold it to him lordship, then it is clear lordship. So without lordship, they are doing to lordship only says here that they will set it auction lordship in auction. And till that nobody approached them, then we are the owner. And even government also, FCI lordship, they also say that no such articles was stolen or theft or lost from their office lordship.
Where is the FIR?
FIR lordship is page 20 lordship. This is the FIR lordship.
Now you have case diary with you.
Reports for the receipt.
Charge sheet has been laid.
Charge sheet not filed lordship.
Charge sheet not filed. Then what have you received?
Also, I'm not so clear lordship because answer is received on the debt lordship.
By LCR, what do we mean? Is it case diary or
This
PRC
part of
case
lordship,
number?
Jimma petition or anything else, lordship, I have not also verified that lordship. Two times I have to give the court bill lordship for that record is.
This LCR was not required actually. This was the record of revision petition before district judge.
Yes, lordship, that may be the lordship. And another factor is that there as the things are lordship, so perishable national lordship, so police cannot take this in their own custody lordship, because their accommodation is essential lordship,
Now, where is this rice lying?
in the police station lordship,
Not in the godown.
not in the Godawan.
460 bags, where in the,
Their sole lordship, they are in travel lordship. So it may be given lordship, then I will lordship, whatever the condition I will give lordship, I'll produce lordship. Or if they need any sample, I'll keep it lordship. Only I want lordship, it may not be damaged lordship. Almost 1 year was gone lordship. So it is perhaps
can
after
you
some.
take information over phone, whether rice has been sold or not? From the OC over telephone and inform this court whether and case diary would be necessary. Since when the affair was launched?
That was lost on lordship 15/5/2023, May of 23 lordship. That is March lordship, almost 9-10 months. Lordship.
Your statements are recorded by the police.
Yes, Lord, I was arrested lordship, so my statement was recorded lordship.
Do we have the 161 statement?
No, the statement is not with me lordship.
Because what was your stand before the IO?
Yes, so let me verify lordship. Only this is the correct position lordship.
But it is a perishable item. If delay is caused, then it will perish. But there is an order of the court to sell. So if in the meanwhile it is sold,
Yes, lordship.
then you will get the receipt of the sale if you are ultimately found to be
Yes, yes,
unlawful.
lordship. So for my instruction, lordship, that is not sold lordship.
Okay, and case diary? Case diary would be required. Because rice, every purchase of rice may not require, whether cash memo is required for every purchase of rice.
Yes,
But
lordship.
this is a huge quantity of rice.
Yes,
for-
lordship, everything lordship, we are also doing the daily market lordship, but without cash memo lordship. And if on the way lordship, the police says, the where from we have said, purchase the vegetable lordship, where from we will able to give the purchaser slip lordship. That is not possible lordship.
Heard, Mr. S. Hawk,
Yes,
learned counsel for the petitioner. Also Miss N. Das, learned additional public prosecutor. During course of the hearing, it came to the light that there is a order of learned Chief Judicial Magistrate Amin Gao. Who passed that order for selling of the rice?
order was passed lordship, there is page 30 lordship, it was signed by lordship, Chief Judicial Magistrate lordship. Page 33 is there,
Page 30.
33.
Chief Judicial Magistrate Kamrup Amin Gao for selling of the seized rice in
That part is only 31
Soigao
pages.
PS case number 3235/2023, and it also appears that the said order was passed on 28/7/2023 with a direction to the IO to submit compliance report within 2 days of the date of conducting auction sale of the seized rice. Learned additional public prosecutor is requested to take instructions from the investigating officers / or the officer in charge of Soigao Police Station as to whether the seized rice has been sold in compliance with the order dated 28/7/2023, passed in GR case number 593 within bracket K/2023 by learned Chief Judicial Magistrate Kamrup Amingao. Learned counsel for the petitioner has also submitted that though he could not produce any cash memo, however, he claims to be the owner of the seized rice as he had purchased these rice from various villagers who have given a letter to that effect to the investigating officer. To whom the letter was given? Ayo,
I will also.
to the investigating officer. Stop. To consider the submissions made by learned counsel for the petitioner.
No, Lordship, it is Lordship to Lordship, the officer is Lordship.
To officer in charge of Soigaon PS. To consider the submissions made by learned counsel for the petitioner. The case diary, perusal of case diary of Soigaon PS case number 235/2023 would be necessary. Hence, call for the case diary of Soigaon PS case number 235/2023. Fixing 4th of April. Fixing 4th of April for case diary.
Lordship, may I pray the Lordship matter may be taken a part of Lordship because otherwise,
Let this matter be kept as part of matter.
Lordship, on the day Lordship and time may be given to consider this petition Lordship, otherwise it will be damage Lordship.
No, police has to sell otherwise, because there is no stay of
Yes,
on the
Lordship.
sale order. If police sells it and ultimately you are found to be an owner, the owner of the seized rice, then you will get the money.
If police sells Lordship, then Lordship only a minimum value will come Lordship.
Okay.
Even Lordship that may not be Lordship, even 1/4 of my purchase value Lordship. That's all Lordship, I am saying Lordship, the instead of given the auction Lordship, it may be given to me Lordship. It may, I may not be.
Let us see on 4th.
Yes, Lordship, obliged.
Item number 18.
Who is the amicus? Any amicus has been appointed? Last time it is mentioned that none appears for. But heard. No, stop. This appeal has been registered on receipt of an appeal petition by the appellant Shri Suresh Gaur, who has been detained in the district jail Difu after being convicted in POCSO case number 16/2022. Stop. The appellant has impugned the judgment dated 4/8/2022, passed by learned Special Judge POCSO Karbi Anglong in connection with POCSO case number 16/2022 under section 376 AB/500 IPC. No. In connection with POCSO case number 16/2022 stop, whereby 2022, comma, 1 month. Under section 376 of Katibi, comma, whereby the appellant was convicted under section 376 AB slash 511 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 5,000 in default of payment of fine to undergo simple imprisonment for 2 months. The appellant was also convicted under section 8 of the POXO Act 2012 and was sentenced appellants namely Johar Ali Sheikh alias Johar Ali Sheikh, Jail Haq Ali and Salema Bibi, impugning the judgment and order dated 20/2/2024 passed by learned Sessions Judge Sirang in Sessions case number 41/2022, whereby the present appellants were convicted under section 304B of the Indian Penal Code and were sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 10,000 and in default of payment of fine to undergo further rigorous imprisonment for 1 year. The appeal is admitted for hearing. Call for the trial court record and issue notice to the respondents.
Yeah,
Since
probably. Notice is probably in this case not required to the inform.
you have made party,
Yes, I have made party because otherwise registry will not pass it and it is the court has to see also
No,
whether it
but-
is necessary or not. Because that notification is now
no,
15.
that notification is mandatory notification.
Yes, that notification in respect of POXO.
POXO is,
POXO and
POXO is the mandate.
Lordship.
In POXO, victim has to be mandatorily made party.
Right.
But otherwise, in criminal appeal,
Okay.
he is the victim or informant.
He is the relative of that victim guy.
When you have made him a opposite party,
Lordship.
natural consequences is that notice has to go. Since issue notice to the respondent, since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with ID, returnable after 3 weeks. After 3 weeks,
But my eye is there, that may be considered. Lordship.
I'm coming to it.
Right.
After 3 weeks. List accordingly. This IA, you will have any objection? But in IA also, she must get a chance to,
If it is 10 years, then it is required.
then the written
Then-
objection.
Yes, otherwise it is not required. That our High Court judgment is also there in this respect. Lordship.
No, written objection, I am not,
Lordship. The opportunity that
opportunity
if
of,
it is 10 years, then it is required.
no,
389 Lordship may kindly see for a
no,
moment.
10 years. If it is 10
10
years, then
and above,
writ-
then it is
written objection may be filed.
Fine.
But otherwise, she
She can-
otherwise may object.
Yes, orally she can. Right. Orally she can object. That is.
Let her go through it. We'll take it up,
Tomorrow, Lordship.
7 years.
7 years punishment. And I will place from the record itself that ingredients is not there. Admittedly, the session judge also admitted that part. So I will place that part.
Session
only.
judge admitted that ingredients are not there.
Yes, and therefore presumption was drawn from Dowry Prohibition Act, which is not a frame, under which charges are not framed.
Okay. So let her get some fair time to prepare. By tomorrow you will be ready. If you are ready, we can take it up. Say boldly. Tomorrow. Okay. Heard, Miss, in I heard Mr. A. Ahmed, learned counsel for the petitioner. Applicant also heard Ms. N. Das, learned additional public prosecutor. This application under section 389 of the Code of Criminal Procedure, 1973, has been filed by the applicant who has referred a connected appeal, that is criminal appeal number 75/2024, whereby the judgment and order dated 20/2/2024 passed by learned Session Judge Sirang Kajalgaon in Sessions Case number 41/2022 has been impugned. Stop. By this application, the applicant has prayed for keeping the sentence imposed on the present applicant under suspension during the pendency of the said appeal, aforesaid appeal, and allowing the applicants to go on bail during this period. Learned counsel, when have you furnished the copies? Today.
On the date of filing itself, on 12/3/2024,
When have you received it?
on the same day, 12/3/2024. Notice is there along with the record also.
Okay. Learned additional public prosecutor prays for some time to prepare herself for arguing this case. The prayer is allowed. Let this matter be listed again on 21/3/2024, along with 21/3/2024. Stop. The record of criminal appeal number 75/2024 shall be tagged with the present interlocutory application.
Obliged.
May I appeal, Your Lordship?
Report was called from the IL version. Today I have received the telephonic instruction version. He informed me that CS submitted version and
Ashit.
Ashit submitted version. He also taking
Vehicle is not. Okay. What is your case?
May I please, Your Lordship? My case is that, my Lordship, I am a owner of a vehicle. At page 13 is the RC. It's a tanker, my Lordship. And it was carrying HPG, my Lordship, hydrogenated pyrolysis gasoline. And it was intercepted by the Bandardoa police station outpost under Vipuria police station on the night of 30/4/2023. And since no valid documents could be produced by the driver, the said vehicle was seized and the driver was arrested in Vipuria PS case number 77/23 under section 379/411, 511 of Indian Penal Code, my Lordship.
Okay.
Thereafter, my Lordship, the driver was allowed to go on bail by the court below. And I applied for Jimma of the vehicle, my Lordship. Page 20. Page 35, my Lordship. My Jimma petition was rejected by SDGM Lakhimpur, my Lordship. Planet SDGM Lakhimpur, my Lordship. Thereafter, I came before this honorable court. And the contents of the tanker, my lord.
Are you an accused in this case?
No.
You are not an
I was
accused.
not arrested. Driver was arrested.
Only
he-
driver is the accused.
Driver was arrested. Yes, he is the accused. my lord.
What is the status of the case? Charge sheet has been laid.
Who is now charge sheet has been-
Against whom?
It's driver, my lordship. I am not there, my lordship, because I went to the police station, I went to the court. And the contents are also given in Jimma to the HPCL, my lordship.
On what ground the prayer for Jimma was rejected?
First, rejected, my lordship. At page 35, my lordship, now it appears that the case is pending in the stage of investigation and charge sheet has not yet been submitted. That as per the decision of Honorable Guwahati High Court in State versus Larger Criminal Petition number 597, 2022, powers of section 450 on CRPC cannot be invoked by magistrate at this stage.
But this. Do you have this judgment?
My lordship, that division bench judgment criminal petition 284, my lordship, is also there. That is also still pending, my lordship. Nothing has, no final order has been passed. It's there.
No, there was a reference made by a single bench regarding applicability of 457 and 4.
Yes, my lordship, I agree to that, my lordship. But
Not in this case.
Yes.
In a different case, the reference was made by single.
yes, that was for now, since in the present case, my lordship, since charge sheet has been submitted, my lordship.
451 is applicable.
Applicable, my lordship, 457, my lordship, since charge sheet has been submitted and IO says that the vehicle is no more required, my lordship.
No, it was rejected on the ground that non-applicability of section 457/451. How will you overcome this observation made by trial court?
My lordship, contention was that since the seizure list has been produced by IO in the instant as it appears by dot, and the case is still at investigation, court is not
No,
empowered to
no.
grant.
Have you gone through this division bench judgment?
Yes,
You have gone through.
my lordship,
The division bench judgment which is referred to in the impugn order.
yes,
Impugn order is referring to a division bench judgment.
yes, my lordship,
On the basis of that division bench judgment, impugn order has rejected your prayer.
yes, my lordship.
Now, have you gone through that division bench order, what it says?
No,
No, you have to go through. You have to assess this court.
no, my lordship, the contention that at the stage articles cannot be released under, however, 457 criminal has jurisdiction to give Jimma. So since seizure list was produced before the court, it was quoted by the court below, my lordship, at page 36, that part, particular part. I'm on that, my lordship.
So on what ground he rejected the prayer?
Has jurisdiction to give custody. The seized property are not produced
No,
before the court.
I want to see this judgment. DB judgment, this year. I'll dispose it of today itself, but I want that judgment.
Criminal petition 284 of 22. Let me try, my lordship, otherwise we will.
Subsequent.
Criminal petition 284 of 2022.
What?
Act was,
No, order dated 2/3/23.
Ending as a movie.
No. Criminal petition number 284/2022.
Ending as a
22. It is not pending. It has been disposed of.
Oh.
I am aware of this judgment.
Yes, I have wrote somewhere.
Here the truck was not produced before. Okay, what?
Result is the page 20, my lordship.
What else you have to submit? Any other submission?
And the Caesar list has been seen by the court below, and the Caesar list has been prepared and submitted in the court.
But the vehicle was not produced.
Vehicles was physically maybe not produced, my lordship.
No, if vehicle is not produced, only then you will get benefit of 457.
Yes, the vehicle was physically not produced as part of it.
Okay. I'm allowing your prayer. I'll write the order in the chamber after going through this judgment.
My lordship.
Your prayer is allowed.
Deeply.
একটু ভিতর দেব।
My lord, in this case, it's a condonation petition, my lord. I was directed to take the service by Dusty. I've taken it, my lord. I filed an affidavit. Yes, she has refused to accept it, my lord.
Who is she? She means the
Respondent.
respondent is your relative,
Yeah, no, she is alleged to be the wife of the
husband,
petitioner.
wife.
Husband, wife. It is a matter of maintenance, my lord.
Then
We are challenging the ex parte order, my lord, because in that case, we have not received the notice and he is a CRPF personnel, my lord. The petitioner works in a CRPF, my lord. He's a constable. He works posted in Maharashtra. So the only
where your wife stays.
in Borpeta, my lord. The same address which was given there. And this is the correct postal address, my lord. Where earlier the registered notices were sent. Then the so 3 persons went there to serve the notice, along with 2 persons, along with an advocate, lady advocate went there.
This is a 125 proceeding.
Yes, my lord. My prayer in the revision petition is that, my lord, just to remand back the matter, so I may be allowed to participate in the proceeding, my lord. Because she said that she is my wife, but I said I never married her.
No, now we are dealing only
The condonation, my lord.
condonation of the
My lord.
petition.
Yes.
No, you have to serve notice on her through,
Madam, we have taken registrars post earlier. Now, in the last occasion, we have taken it by Dusty.
Dusty will not do in criminal proceeding. If it, more specifically on the event of refusal in case of hack, you have to take fresh steps by registered post with AD or through other mode, or through the officer in charge of the jurisdictional police station.
Then, madam, to the officer in charge of the judicial police station, madam. Only, madam, the problem is that, madam, the warrant has been issued in this case, and he is the CRPF personnel, so his service is at stake, my lord, now. That's the issue.
No, this case was this ex parte, it was decided.
Yes, my lord.
Have you approached the trial court for vacating the ex parte order?
The expert is the order was directed, madam. You are directed to pay the maintenance of maybe 10,000 per month.
That was an ex parte order.
Yes, my lord.
You have not approached the court for vacating that ex parte order.
No, my lord.
That you could have done.
Yes, ma'am. But because there's a delay, my lord, so the delay was there.
Heard. Mr. What is your name?
MK Boro, my lord.
Heard Mr. MK Boro, learned counsel for the petitioner. How you approach the respondent number 2 for
Dusty service, my lord.
how you try to,
My lord, in para 3, my lord, I've said, my lord. One person took the records for me on 26/9/2023, and on 27/9/2023, along with an advocate, my lord, they went to the house of the respondent, my lord. Number 2.
heard Mr. MK Boro, learned counsel for the petitioner. Also heard Mr. KK Das, learned additional public prosecutor. From the record of this case, it appears that by order dated 10/9/2023, this court a coordinate bench of this court has permitted the petitioner to serve the notice on respondent number 2 by Dusty mode. The petitioner has filed an affidavit to the effect that when the counsel for the petitioner went to serve the notice on the respondent number 2, as per directions of this court, the same was not accepted by respondent number 2. Where is the provision for dusty mode of service? I'll allow it if you can answer my query.
And criminal,
Stop. What was the? Stop. It appears from the court that the respondent number 2 is the wife of the present petitioner and their relationship is strained and which
no,
gave
she's said to be wife, but I said I have never married her.
okay,
In fact,
and their relationship is strained, and under such circumstances this court is of considered opinion that service of notice through dusty mode may not be appropriate mode of service. The learned counsel for the petitioner also failed to respond to the query posed by this court as to the provision of service of notice through dusty mode in criminal cases. Under such circumstances, the petitioner is directed to take fresh steps for issuance of notice to the respondent number 2 through the officer in charge of jurisdictional police station, that is
Howley
Bij-
PS,
Bijni,
Howley madam.
Howley Police Station. The petitioner shall furnish the copy of notice along with the annexation, along with the copy of petition, copy of condemnation petition, as well as criminal revision petition to the registry, which in turn shall forward the same to the officer in charge of Howley Police Station. Stop. After receipt of the same, the officer in charge of Howley Police Station shall ensure service of notice on the respondent number 2, Srimati Mosumi Brahma, and submit a service report to this court through the registry of this court before next date fixed. The petitioner shall take steps within 3 days from the date of order. The notices are returnable on which date?
No, not as soon as possible, my lord, because his serviceman is there.
Bihur aa gaya. 9th April.
My lord.
Let this case be listed again on 9th of April. 2000.
Highly obliged, my lord.
May I please? Lord? But as per office note, my lord, 25, 15/3/24, my lord. The service upon the respondent number 2 is complete, my lord. So let the matter may be fixed for admission. My lord.
What is this interlocutory application is for?
My lord, subsequently, charge sheet has been submitted, my lord. That was brought on record, my lord. Subsequently, charge sheet has been submitted and someone issued to the petition.
The offense is under
422/406.
office note.
15-3.
No, this interlocutory application is for
Oh,
or
my lord,
bringing on-
earlier challenged the affair. Subsequently, charge sheet has been submitted. And that charge sheet was, my lord, put under challenge in the IA, my lord.
in IA, in IA. Heard Mr. R. Ali,
Islam.
H. A. Ahmed, learned counsel for the applicant from the office note dated 23/8/23 in the
15-3. 15-3.
it appears that the no, which office note you are mentioning?
15-3.
There is no office note on 15/3. 15/3 to lekha hai nahi.
Office note is there.
15/3.
Office note আছে.
15-3.
Office note is there. Lordship.
15/3.
Lordship, I forgot the date, but office note is there where it is stated that service was completed
Dekhao.
as per office.
Sauk.
Yeah, maybe in the.
Yeah, this Sauk. Okay.
Lordship, maybe in the I.
Yes, it is there. On perusal of the office note dated 15/3/2024, it appears that the notice on the respondent number 2 has been duly served. Stop. What is your prayer in this?
So quashing the affair and as well as the entire proceeding.
By this interlocutory, stop, by this interlocutory application, the applicant has prayed for
See, what a search Lordship. And earlier in the main petition, it was for the FIR.
prayed for an additional prayer, that is quashing of the charge sheet. Prayed for inclusion of an additional prayer, that is quashing of a charge of the charge sheet number 370/2020 dated 35/2022 in Tejpur PS case number 67/2019. As earlier, the petitioner has filed the criminal petition number 978/22, praying for quashing of the FIR only. However, meanwhile, charge sheet has been laid, and therefore this interlocutory application has been filed for making additional prayer. The additional public prosecutor does not oppose the prayer, hence the prayer is allowed. This additional prayer has to be added to your original. That prayer has to be there. Here, what prayer you have made? You go through, read your prayer. Now, what relief you want in this IA? You tell me about the relief which you want. I'll give that relief.
Washing of the charge sheet and the proceeding of PSC number.
No, but that has to be in the main petition.
Lordship, at that time, the charge
Okay.
sheet was not laid at that time. When the main petition was filed.
So main petition has to be amended. This interlocutory application, you ought to have prayed for adding one more prayer and necessary amendments in your criminal petition. This cannot be treated as an parallel criminal petition. This interlocutory application has to be disposed of. In view of the, what was the last name? Where is the law? The petitioner shall make necessary amendments to the prayer as well as prayer portion, as well as whenever the changes are required in the criminal petition number 978/2022, and accordingly take steps. Stop. This interlocutory application is accordingly disposed of. You make the
Amendment petition.
the petitioner shall file the amended criminal petition within a period of
1 week.
1 week from the date of this order. List the criminal petition numbers 978/2022 accordingly. This interlocutory application is disposed of.
Before your lordship rises, my lord, item 48, stay matters, my lord. No, this relates to an NIA case of 2012, my lord. I am appearing for the sole respondent. Only thing, though I received, though I have filed wakalatnama, I have not received, notice has not been served upon me.
I've got a petitioner.
He may be directed to file, give a copy to me, and
Copy I will serve, let the matter come up
after
vacation.
Bihu, a date may be fixed, my lord, so that it can be disposed of, very small matter, my lord.
I'm not taking up other matters.
My lord, item 33 and 38, my lord, very urgent matters, my lord. Next Thursday, my lord, for listing. Item 33 and 38, my lord.
No, wherever there is urgency,
Yes.
you make a mention to the court master. He will see our board, accordingly accommodate all of you.
Because only for 33 is languishing in jail, my lord. The criminal appeal is admitted. It's an NDPS case. My lord,
No,
52
this
is
will
not
be-
complied.
You will be accommodated, but subject to the cases on our board. So court master will give dates wherever there is an interim order shall continue. And wherever there is no special mention made by any of the council, the cases will be left over and registry will give the dates accordingly.